Good morning all, it's 29 minutes past 9. We are going to start the proceedings. Please make sure that your devices are off, on mute, whatever it takes to keep them quiet. Thank you.
Yes, good morning, Ms. Hassim.
Morning, Chair. Morning, Commissioners. We are meant to be dealing with the application by Mr. Mokgotsi for the recusal of an evidence leader, and I will be making submissions in opposition. But I don't see his legal representatives, although I believe they are present, and I'm advised that Mr. Mokgotsi is running late. And I think we need to hear from his legal representatives how late.
But at this stage, I don't think we need him right away. He'll only be needed depending on what our decision is right at the end.
That's correct, Chair. We could proceed without him.
So what we want is his representation, his legal representation at this stage.
Thank you.
Yeah. And I see Mr. Sekhaja. And counsel, yeah. Good morning, Mr. Sekhaja. Oh, who's leading today? I greeted you because you were leading last time.
Good morning, Chair.
Yes.
That is correct. I was leading last time.
Yes.
But for today's purposes, Counsel, Advocate Mohamani, she's the one who's going to be leading.
Thank you.
Morning, Chair. Morning, Co-Commissioners.
Good morning.
It's Mohamani.
Yes, Commissioner, it's Mohamani.
Please spell it for me. I just want to.
Surname, Chair, it's M-O.
Just
H-O.
H-O-M-A.
M-A. Chair.
Mohamani.
Yes, Chair.
Thank you.
Thank you, Chair.
Thank you. Are you ready, Ms. Mohamani?
Yes, Chair, we are ready to proceed.
Yes.
Chair, prior to starting, I thought it would be prudent to inform the Commission. We spoke to Mr. Mokgotsi. He said that he's delayed in traffic, but his GPS shows him that he'll be here in the next 15 or 18 minutes. I'm uncertain how the Commissioners would like us to deal with the matter. Do we proceed in absentia or do we wait for him to arrive? I seek the Chairperson's direction.
To my mind, this is very much akin to a motion matter in court. You don't need the litigant in such a matter. So let's start.
Thank you, Chair. Chair and Co-Commissioners, this is an application that is being brought by Mr. Opa Brown Mokgotsi for the recusal of Matthew Carlson SC, who is the chief evidence leader in the proceedings where Mr. Mokgotsi is witness. Now, Chair, what the relief that the applicant seeks is that Advocate Charles Carlson be recused from the matter and an alternative evidence leader be appointed to cross-examine Mr. Mokgotsi. the basis of the application rests on the possibility of biasness or impartiality. And this, Chair, stems from
Actual bias or actual bias alternatively perceived?
perceived bias, Chair.
Not actual, but perceived.
Perceived bias.
Thank
yes,
you.
Chair. And the reason for this perceived bias is as a result of events that took place before the Commission on the 9th of March and the 10th of March. Mr. Karim Suleiman came in to bear testimony before the Commission. Now, during the said days when Mr. Suleiman was giving testimony, there was communication between the evidence leader and Mr. Mokhotsi, who's the applicant for the recusal. That communication comes in the form of WhatsApps.
I think there is an antecedent question, a legal question, because how we grapple with the events that you referred to depends on what the law is. Because you must first know what the law is, and then you apply the law to what you've referred to as the events, which effectively are facts or factual issues. In your application, you rely on SARFU and other cases. Those cases relate to situations that involve decision makers in whatever form those may manifest. The respondents have taken the point that those cases are irrelevant to a situation like the present, where a decision maker is not involved. And the point made is that the chief evidence leader is not a decision maker. So what law are you relying on? Because the point is correct that the cases that you've referred to in your application relate to decision makers. So are you continuing to rely on those cases? If so, on what basis would they be applicable here?
Chair, I would be inclined to concede that the cases or the case law that was used by the applicant is that of the decision makers and not the parties who partake in the proceedings. But then from that, Chair, I will also submit to the Commission that case law has been brought to the attention of the Commission in the form of an answering affidavit by the respondent. And the cases that are therein mentioned do make provisions for instances where prosecutors and, with this case, an evidence leader may be recused from certain proceedings.
Can you state the principles insofar as you see them, and for us to have an idea of the case you want to make out?
Chair, there is the matter of the DPP of the Western Cape versus Killian. It's a 2007 decision in the Supreme Court of Appeal. The full citation is at 169 in brackets RSA. It's DPP, Western Cape versus Killian in brackets 2007, SCA 169.
Is it the case, same case cited in footnote 16 of the answering affidavit?
Yes, Co-Commissioner, it is.
Footnote 16 of the answering affidavit on page 70. That's where the citation
That's
is.
footnote
16 on page 70 of the record.
P70.
And the test there is substantive unfairness.
It's substantive fairness, yes, Commissioner.
Unfairness.
Unfairness, yes.
So that's basically what you'll be relying on. There's also reliance on porridge versus, is it NTPP, by the respondent.
Yes,
By
Chair.
the respondent. I would assume that the test is the same
Yes, Chair.
in porridge as well. All right, please continue then. You were dealing with the events.
Maybe just to correct the citation, as we have it here, it's 2008, volume 1, SACR, page 247 SCA. Is that the one you're referring to? Because you've given us a different citation. No,
Commissioner,
let me
according
get
to the
confirmation from
papers,
her.
it reads as 2007 SCA 169.
Even
Right, I don't know
if
what
it is a Zaska citation, it will still be wrong because you must have a Zaska number because I assume that the 169 is the page. So there must be two numbers, the Zaska number and then there should also be the page number. So the citation is still wrong. But anyway, yeah, let's continue.
Chair, as I was previously submitting,
Yes,
as I was
please.
previously submitting, Chair, previously Mr. Mokgotsi was before the Commission with a different legal team. Subsequent thereto, in January of 2026, the legal team withdrew from the record. Now, Mr. Karim came on to give testimony before the Commission, and this occurred on the 9th and the 10th of March, respectively. And it's at this time when there was communication between the evidence leader and Mr. Mokgotsi. Now, this communication comes in the form of telephone calls and WhatsApp messages. Now, the content of the WhatsApp messages which are contained in the papers is that there was communication of some sort. Now, the dispute is factual in the sense that the applicant gives a different version of what was discussed, specifically with the telephone calls, and it differs significantly from what the respondent replies. The applicant in his papers say that the evidence leader had suggested that he can be able to assist him, he can be able to protect him in the event that he gives evidence that is adverse against Mr. Karim Suleiman. That is the case in a nutshell. Now, a meeting was to take place on the 10th of March where discussions would go forward regarding the type of evidence.
Is it not correct, though, that we would only have a full picture of what actually transpired between Mr. Mokgotsi and the chief evidence leader if we are given the full picture of the exchanges between Mr. Mokgotsi and the chief evidence leader? Is that not correct? I don't think that's something you can find in the papers. It's a question that you should be able to answer off the top of your head.
Chair, the intention with the perusal was to take the Commission to the attachments of the WhatsApp messages which would have the dates and the times when the communication started between both parties.
I don't think that's what I'm asking. What I'm asking is, do you agree or do you not that for us to get a full picture of what actually transpired between Mr. Mokgotsi and the chief evidence leader is if we have a full picture of the exchanges themselves. Is that so or not?
That is so, Chair.
Has Mr. Mokgotsi given us that full picture?
Mr. Mokgotsi has given us what he has in his possession in the form of WhatsApp messages. Further thereto, with regards to the telephone calls, he has given disclosure of what was discussed in those telephone calls that took place. I'm uncertain whether there's anything that he has omitted to give to the Commission.
I will not get into much detail. I'll just mention one and you'll correct me if I'm wrong. There's the one during Mr. Karim's testimony where Mr. Mokgotsi sent to the chief evidence leader what was normally used as laughing emojis, but with a person with tears coming down the person's face. But I think you know what I'm referring to. That's an example of something that was excluded. And from what you said, I understand you to be suggesting that all that Mr. Mokgotsi has excluded are just phone calls. But what I've just referred to, I think that too was excluded. That's just one example.
That is...
Or am I wrong?
There is an explanation that is contained in the replying affidavit about...
Am I wrong?
No, Chair, you are not wrong.
Yes.
However, Chair, when that issue was raised, Mr. Mokgotsi then goes and he addresses the issue and he gives an explanation as to why that was omitted in the images or the WhatsApp chats that were handed in as annexures.
And what's that explanation?
Chair, the explanation is that he took what he thought was necessary in order to make a case, and this Chair can find at paragraph 43 of the replying affidavit.
Page?
43, Chair.
Page in terms of the entire pagination, not the page of his affidavit.
267.
Do you want to take us through what you've just referred to, please? That explanation.
Chair. Chair will find at 267 of the bundle.
You said paragraph?
Paragraph 43, Chair.
43, thank you.
Yes, Chair.
This is not addressing the issue I'm raising with you. There he says that he deleted calls. I just referred you to something that is not a call. And that is what I was engaging you on now. That is something that is not a call. Go to page 97, paginated 97 of the papers, and there's what I'm referring you to. You see those three emojis there? Someone laughing, they have tears, and their faces
I see them,
tilted. Yeah.
Yes, Chair, I see them.
So that's not a call. So 43 does not answer that. Paragraph 43 at 267 does not answer that. And I said I'm referring to this just as one example. Maybe my colleagues, Ms. Hassim, I do not know, but perhaps they may refer to something else. But I just raised this one example to say to you, it is not correct that all that he took out were calls only.
Now, Chair, in response to that, if the commissioners look at paragraph 42 of the same affidavit that I referred the chairperson to. It reads that the sole intention behind the deletion was to protect my conversations with the third respondent from third persons.
That doesn't make sense to me. What does that mean? I mean, if he is saying, here are our conversations, however they may manifest, and these communications show that the chief evidence leader is perceived to be biased. That's the language you use in the application. How do you then go ahead and protect him? You should actually be seeking to embarrass him and show what a bad person he is by showing what he has communicated, or by showing what you have communicated, if in your view it shows the perception of bias, or it demonstrates the perception of bias. So I just do not understand. What do you mean by this? Or rather, what does Mr. Mokgotsi mean by what he says in paragraph 42?
Chair, in response, I'll submit that, save for paragraph 42 and 43, there's nothing further that deals with these deleted telephone calls and the emojis, and there's no provision in the affidavit nor the reply that gives a basis for the deletion of same.
Are the deletions not actually calculated to avoid the possibility of interpreting these chats in a manner that disproves what Mr. Mokgotsi is saying? Is that not a possibility? That is, that they are calculated for that purpose?
Chair, in response, I will submit that the interactions and the events that took place, the end result was the belief that if Mr. Mokgotsi does not provide information or useful information or helpful information, the condition that he will be protected.
I'm not sure that that answers the question I've put to you. My question is about, isn't there a possibility that the deletions are calculated to create the impression that Mr. Mokgotsi is pushing for? So he deletes whatever may be at variance with or at odds with what the chief evidence leader is saying. Is that not a possibility?
Chair, it is a possibility. And it's also a possibility that none of us know the contents of these deleted telephone calls.
We know the chief evidence leader has put up everything, so we do know.
But Chair, it's the same information.
Except of course for calls, we are not in a position to know the content of the calls themselves. But as for texts, the chief evidence leader has put up everything. So in that regard, we do know.
Hence, Chair, when I responded, I spoke about the call specifically.
Yes.
I said, where we are seated and where the commissioners are seated, none of us know the contents of these deleted phone calls that took place between the two parties. Now, having said that, I would not be in a position to submit whether the deletions were to push a certain agenda or to conceal a certain intention, because I was not privy to the calls and neither was the commission. It's two individuals where one says, I deleted for this specific reason and this was requested of me or it was asked of me. And there's an individual who then says, I did not ask this, I asked that. So the dispute now tends to be a factual dispute about what was contained in the phone calls. I cannot make any submissions on that.
Here's what I understand the respondent's case to be. Most of the calls, the bulk of the calls were by Mr. Mokgotsi and not the other way around. Do you agree with that?
Chair, I'll agree with you. And in my agreement...
Let me continue with the point. I just wanted to see if you agree or not, so you say you agree. Now, if I understand the respondent's case correctly, it is that Mr. Mokgotsi was persistently knocking at the door of the chief evidence leader, and he was the one, through, amongst others, calls. The many calls which you accept largely came from him, Mr. Mokgotsi. So he was knocking at the door of the chief evidence leader, seeking to be assisted. So he is the one that was seeking to be assisted. And if I understand the case, that is amongst others shown by the fact that he made several calls. He is the one that largely made calls to the chief evidence leader and not the other way around. That's how I understand the case. So we may not know the content of the calls, but the point appears to be that from the fact that he is the one that made most of the calls, that appears to be an indication that he is the one that was, if I am to speak loosely, was seeking the chief evidence leader out. Do you get my point? Go, for example, to page 95, 96 as well. And there you will see miss voice call, miss voice call, miss voice call, miss voice call. And all of those, and next page 96, miss voice call, miss voice call. There's another one, miss voice call, and all the way down. I'm sure you could go on and on. 97 as well, same thing. All of those are miss voice calls coming from Mr. Mokgotsi. So it's Mr. Mokgotsi who's seeking out the chief evidence leader. It's not the chief evidence leader who's desperately trying to get hold of Mr. Mokgotsi. It is Mr. Mokgotsi who appears to be desperately wanting to get hold of the chief evidence leader. So I'm saying, yes, we do not know the content of the conversations, or rather, what conversations actually took place where there were calls that were taken between them. But from the fact that Mr. Mokgotsi appears to have been the one seeking out the chief evidence leader, that may well be, I'm not deciding that point, I'm engaging you on it, that may well be an indication that it is Mr. Mokgotsi who wanted assistance from the chief evidence leader and not the other way around, as Mr. Mokgotsi is suggesting in his application. What's your comment? And comment specifically on the several calls that Mr. Mokgotsi is making here.
Chair, on page 95, I concede that...
It's not only 95, it's 95. I took you to 95, 96, 97, and I'm sure
Chair, I'm moving through the pages.
Yes.
Now, if I may be allowed to start with the first page, which would be 95. Chair, I concede that there is a missed call that came from Mr. Mokgotsi. Now, there's a call that goes back to Mr. Mokgotsi with a duration of 3 minutes that comes from the evidence leader. Subsequent to whatever that was discussed in that call, there's a question that comes from Mr. Mokgotsi that says that, how do you protect me? The next question says, this guy, I believe that Sana maybe wants to take me down. It's open to...
Yeah, how the respondents have read that, they quote this as is, and then in brackets they say, this guy wanna take me down, something like that.
That is what
This guy-
how I understand
This,
it.
this guy wants to take me down, yes.
Now, Chair, the calls move further towards the night, and well, I suspect that the both of them at some point went to bed. Now, on the 10th of March, there's a missed call in the morning. If Chair moves to page 96, there's subsequent missed calls, and then there's a text that comes in which says that, are you proceeding with him or are you going to need info prior? Again, Chair, what info does the evidence leader require prior to questioning Mr. Suleiman?
The evidence leader the chief evidence leader says that Mr. Mokhodzi made the offer that he had information, new information to give to the chief evidence leader.
Now, Chair, with regards to that, Mr. Mokhodzi further says that during this phone call, there was a discussion about additional information that the evidence leader sought, which was in the form of proof of payments and bank statements. And then he then says in his affidavit that he became aware on that 10th of March that the evidence leader has gotten hold of these proof of payments and the bank statements. Now, he further asks, thought you may need something. Now, Chair, my submission is that the commission may look at it to say that Mr. Mokhodzi is the one who reached out. And according to these records, indeed that is the case. Now, when Mr. Mokhodzi reaches out, the evidence leader also entertains him. And he could have been told off, he could have been...
Why should that be the case? Why should he tell him off? If he says, I have information, it is information that is relevant to what the commission is about. I want to give you that information. Why should the evidence leader not be interested in that? And we know, for example, that the chief evidence leader was not cagey or secretive, confidential about any of this. Remember, there are texts written to two other people within the commission. I think it's two.
Yes,
one is
Mr.
definitely an
Jamini
investigator, and there's another second one. I
Yes,
don't know whether
there's a
that's
Mr.
also an
Jamini
investigator.
and somebody else.
Yes,
Yes,
two investigators.
Yes.
So he said, I have an appointment with Mr. Mokhodzi to consult with him. And that's basically on the new information that Mr. Mokhodzi says he has. Can you please join me? If the chief evidence leader wanted to act improperly, do you think he would have invited other people to come listen to him? Going to say to Mr. Mokhodzi, I want you to give any dirt you can give me on Mr. Karim. I'm going to get him and I will protect you. Would he have acted in that manner?
Chair,
Or perhaps let me go back to my initial question, which is, to use your language, why should he have told him off? If he said, I have information, why should he not listen to what that information is? That's the first point. And then the second point is, if there was anything the matter with regard to his conduct, that is the chief evidence leader, would he have invited other people to come witness what he wanted to do? And please answer both questions.
On the first question, Chair, there is nothing underhanded with the behavior of the evidence leader when he called two other parties or members, if I may so put it without labels, who form part of the team for the commission to come with him when he goes to meet with Mr. Mokhodzi. Now, then the question turns on, would he have done that if he knew that he was going to do something underhanded with Mr. Mokhodzi? Chair, the allegation here is not anything underhanded. It's got nothing to do with underhandedness. It's the phobia that
I understood it to be Mr. Mokgotzi's case that everything about what the chief evidence leader did was underhanded. So what you are saying now
Chair.
seems to cut across that case.
No, Chair. What he
Yes,
says,
yes.
what he says is he wanted valuable information. He wanted me to throw Karim Suleiman under the bus. He wanted to give him something that would embarrass Suleiman. Now, in the event that I cannot do that,
So are you now saying that there was basically nothing wrong that the chief evidence leader did? Which you cannot say if your case is that the chief evidence leader must be taken out of this case. You cannot possibly say there's nothing wrong he did.
Chair, there has been interactions. I want to select a word wisely. There has been interactions between the evidence chair and Mr. Mokgotzi,
Yes.
which chair have strained whatever relation that they might have had. And to demonstrate that even prior to the recusal application,
I'm going to get lost. I'm very, very sorry. My most sincere apologies, but I'm going to get lost. My first question to you was, why do you say that the chief evidence leader ought to have told Mr. Mokgotzi off? Again, I'm using your language. When Mr. Mokgotzi was saying, I have information for you, information that is relevant to the commission, why should the chief evidence leader not listen to Mr. Mokgotzi to hear what the information is? Maybe instead of what I did earlier, which was to ask two questions, let me ask that one question and get your response on it.
Chair, in response, I will submit that when Mr. Mokgotzi was giving testimony, the evidence leader labeled him a liar. Now, you have this person who's a liar, and he comes to you and he says he has information, and you take the word of a liar and you entertain him and you run with that information.
But have you seen what the chief evidence leader's treatment of what you've just said is in his affidavit? Have you seen that?
Yes, Chair, I've seen it.
What does he say? Let me tell you, to save time. The chief evidence leader says that I would still listen or consider what Mr. Mokgotzi says. But from where I am sitting, because Mr. Mokgotzi has been shown to be a liar, I would want to have corroboration of whatever it is that he were to tell me. That's his response. So I think that answers the hypothetical question you are raising.
Chair, I'll respond by saying that the corroboration comes after they have engaged each other for 2 days. It comes late on the 10th of March. They make an appointment to meet at 13
I'm not sure I
4.
get I'm not sure I get what you mean by referring to corroboration coming to the fore. Because corroboration would only be after the chief evidence leader had received the information. Then as to what he would do with regard to how that gets corroborated is something that would arise after receipt of the information. So I don't follow.
I'm in agreement with the chair.
Yes.
Why I'm raising this issue, Chair? There's numerous phone calls.
Yes.
There's messages, there's missed calls, there's emojis that come for a period of 2 days. And the appointment is finally confirmed on the second day at 16:13. And they've been engaging each other for 2 days with telephone calls that, as I had previously submitted, I know nothing about, and the Commission doesn't know the contents thereof.
But I think we all agree, though, that whatever was said in those phone calls was not about the actual content of what Mr. Mokhodzi could or would have said, because that is exactly what the consultation was to be about. So, no question of any corroboration at that stage. So, yeah.
I'm in agreement, Chair.
I will stop there and say, subject to whatever issues my co-commissioners may want to raise, you may continue with your argument, and I'll try not to disturb you any further.
Maybe before you continue, if you look at page 76, paragraph 8.2, that is the evidence, Mr. Chaskalson's affidavit. And in there, that's the answering affidavit.
Yes, Commissioner.
8.2, he says the suggestion that Mr. Mokhodzi could provide evidence. The suggestion that Mr. Mokhodzi could provide evidence against Mr. Karim first came from Mr. Mokhodzi himself, unsolicited by me. That's what Mr. Chaskalson says. Then you look at how Mr. Mokhodzi deals with that in his replying affidavit. You'll find it at page 264. It's quite a lengthy response. It goes from paragraph 22 up to 29. But in all of that, he does not deny that he's the one that approached Mr. Chaskalson with an offer to provide information about Mr. Karim. And in your exchange with the chairperson, I understand you in your own way to not be disputing. That's how this started. Now, if that is the case, and we have to accept that is the case, because in the replying affidavit it's not denied. So Mr. Chaskalson's word on it would be the last word on it. Now, if that is what happened, how is it a problem or even a ground for a complaint that finds a recusal application that they then continue conversations about Mr. Karim? How can it be?
Can the Commissioner repeat the question for me?
If the admitted case or the undisputed case, let me make it the undisputed because Mr. Mokhodzi does not dispute it. If the undisputed case is that Mr. Mokhodzi is the one that approached Mr. Chaskalson with an offer to give him information about Mr. Karim, that's the case, right? And I'm saying that's not disputed. Your client had the opportunity to dispute and say exactly what happened in those conversations, but he doesn't dispute it. So we must accept that the true position is that Mr. Mokhodzi, unsolicited, offered to Mr. Chaskalson that I will give you information about Chaskalson. Now with that, about Mr. Karim, with that, knowing that, how can it be then a legitimate ground of complaint that Mr. Chaskalson was having discussions with me to give him information about Mr. Karim? How can it be? Just logically, if nothing else, just logically, how can it be? a legitimate ground for complaint and therefore for recusal.
Commissioner, the issue relating to a belief of unfairness or biasness is subjective. And it is not disputed that Mr. Mokhotsi reached out to Mr. Chaskalson. Now, what then transpired from there on could have or did create the impression that moving on, there will be a biasness of some sort, or he will not be treated fairly. And this is what prompts the application.
Okay.
And prior to the application being brought, there was a letter that was addressed to the commission.
No, don't go to the letter. You're not answering my question. I'm going to repeat it. But before I do that, let me correct you. You are incorrect. It's an incorrect standard to say the issue of biasness is subjective. It's an objective test. I expect you know that. So the test is objective. That's one correction. Two, my question to you, don't go to letters that were written to the commission. My question to you is simply this. Mr. Mokhotsi approached Mr. Chaskalson with an offer to give him information about Mr. Karim. That's what happened according to Mr. Chaskalson's affidavit, and Mr. Mokhotsi does not deny it in the replying affidavit. And in your engagement with the chairperson, I said to you that as I was listening to you, you seem in your own way to accept. That's what happened here. So having established that, you and I agreeing that Mr. Mokhotsi is the one that made the approach and offered to provide information about Mr. Karim, how can then it be a legitimate complaint that Mr. Chaskalson was talking to me about Mr. Karim, to get information about Mr. Karim? How can it be? In fact, it can never be a basis to claim bias until you address my question about how can this be a legitimate complaint? You offered, I'll give you information about Karim that relates to your terms of reference. I have stuff on Karim. Then Mr. Chaskalson says, okay, give me that information. If the engagement is about information relating to Mr. Karim, which is originally offered by Mr. Mokhotsi, how can that be now a legitimate complaint that, oh, Mr. Chaskalson wants to talk to me or was talking to me about Mr. Mokhotsi? Firstly, how can that be a legitimate complaint? And I want to suggest to you, it's not legitimate. It can never be a legitimate complaint, the fact itself that he's talking to me about Karim, because he offered, unless you want to tell us that Mr. Mokhotsi was setting Mr. Chaskalson up when he offered him that I'll give you information about Mokhotsi. Perhaps he was setting him up so that he can do this complaint. But we have to accept he was in good faith when he made the offer. So I'm not casting aspersions on him at this stage. I accept he was in good faith when he said, I have information that's relevant to you about Mr. Karim that I'm going to share with you. Having accepted that, I'm suggesting to you, in fact, I'm putting to you that it can never be a legitimate complaint that he was talking to me about Karim. Therefore, firstly, he was talking to me about Karim can never be a basis for a proper or legitimate complaint. Two, it could not under any circumstance, be a basis for claims of bias or fear of bias. It can be. So I would like you to say, why am I wrong in what I'm saying to you, in what I'm suggesting to you?
Commissioner, if it is looked at in isolation that Mr. Mokgotsi approached the evidence leader, then that cannot be a ground for this application. If the mere approach on its own is what the recusal is about, I'll have to concede. In isolation, it is not a ground to bring a recusal application, neither is it a ground to anticipate any form of biasness from the evidence leader.
All right, that's fine. So what else do you say we should look at? So we've settled that the approach and the conversation that follows as a result of that approach in itself is not a ground for complaint, for legitimate complaint, but for recusal. But then you say, don't look at it on its own in isolation. What else are you saying we should look at that then supports the complaint and the ground for recusal?
Commissioner, if I may refer you to page 38 of the bundle, it's back to the telephone calls and the WhatsApp messages.
Yes.
Now, this is a continuation from the dates that we spoke about prior, but there is a message here and it reads from Mr. Mokgotsi, I believe you can help me. Now there's a response after that which says, I think so too, but you can't mess me around. Now,
What about that? What are you saying about this exchange?
Chair, my submission is we concede that from the onset, Mr. Mokgotsi approached the evidence chair and they engaged in whatever form of communication that they engaged in. And as the commissioner had said, the purpose of the exercise was bona fide, to say, I have information, I can help you. Now, as the events transpired, the impression that was formed, according to Mr. Mokgotsi's case, is that if I do not bring anything valuable, if I do not bring anything useful, then I cannot be indemnified or I cannot be saved. If Chair looks at page 16 of the founding affidavit, it will be
No, before you go to page 16, I think let's first settle what page 38 is about, the reference to page 38. The text reads, I believe you can help me. And we know from the papers, and you've just said, that is Mr. Mokgotsi saying to Mr. Chaskalson. And Mr. Chaskalson responds, I think so too, but you can't mess me around. What are you saying about this?
Chair, Commissioner, I apologize. What I'm saying about the messing around, it forms an impression that give me the information, don't play with me.
Where does it form that impression? The text doesn't
Chair,
say...
if you read...
Sorry, let me finish.
I apologize,
That's
Commissioner.
okay, no, you don't have to apologize, it's okay. The text says, but you can't mess me around. I think so too, but you can't mess me around. Where do you see what impression it forms and what it is speaking to? Where do you see that?
Chair, now-
Because I think keep in mind, also I want to suggest that you also don't read that. A proper way of reading any document is to read it in context. You know that, right? So look at the context of the communication from the beginning to the very last one, and the one that precedes. I believe you can help me. It's preceded by when am I going to be heard? When are you bringing the subpoena? Which date do you have in mind? When I know we can fit you in. That's Mr. Chaskalson. Yes.
Commissioner.
Yes,
this-
and sorry, let me finish. I just want for us to be in agreement about the context in which this text appears.
Yes, Commissioner.
That whole page, it starts with what happened to you. That's Mr. Chaskalson, and in his affidavit, he does say that they had been waiting for Mr. Mokhosi to come here for an appointment. Mr. Chaskalson and the two investigators. And Mr. Chaskalson says in his affidavit, we waited for 2 hours. He complains. He says, we actually wasted a good 2 hours waiting for Mr. Mokhosi and he didn't arrive. And that explains, according to Mr. Chaskalson. So what Mr. Chaskalson says in the affidavit, you would have seen. He says, we had an appointment with Mr. Mokhosi for the morning, right? He didn't arrive in the morning. We rescheduled for 2 o'clock. He didn't arrive at 2 o'clock. And Mr. Chaskalson complains in his affidavit that he wasted our time. We waited for a good 2 hours for him to arrive. The three of us, 2 investigators and Mr. Mokhosi and Mr. Chaskalson. And he explains that message. He says, the message, what happened to you, is because Mr. Mokhosi had not arrived here at the college, not a secret meeting, here at this venue for a consultation. And then Mr. Chaskalson says, and I read this only to say to you, context is important. We should not read selectively WhatsApp messages. After Mr. Chaskalson says, what happened to you, he then again says, I can't hear your evidence tomorrow. Note the date of the text is the 12th of March. Mr. Chaskalson says, I can't hear your evidence tomorrow anymore because we haven't met on the new info yet. I will see what else works on the calendar and get back to you. And then Mr. Mokhosi asks at 11:31, when are you bringing the subpoenas? That's Mr. Mokhosi. He indicates a willingness to come and testify. Mr. Mokhosi again asks, which date do you have in mind? Mr. Chaskalson answers him, when I know when we can fit you in, I will tell you. That's Mr. Chaskalson. Then Mr. Mokhosi says, I believe you can help me. That's his response to when I know when we can fit you in, I will tell you. He says, I believe you can help me. That's Mr. Mokhosi. Mr. Chaskalson says, I think so too, but you can't mess me around. Now, remember the context I said to you is missed appointments. But you can't mess me around. And then Mr. Chaskalson finally, in that stream of communication, says, I will try to work out when we can fit you into the calendar. It will have to be next month. I will get back to you next week with possible dates. Now, nothing in this sequence of communication gives you or Mr. Mokhosi any basis to say that which you have selectively read, Ms. Mahomane, I think so too, but you can't mess me around, means give me something and then I will protect you. There's absolutely no basis to present that part of the text in that way when you look at the context?
Commissioner, I'm inclined to agree with you thus far. Now, further to the response that you can't mess me around and I'll try to work out when we can fit you into the calendar. There's a response from Mr. Mokgotsi which says that how do I get involved and finish, which I wish I knew what to do exactly.
You say what about it?
We are underneath fit you into the calendar. It will have to be next month message.
Yes, I can see that. That is on page 39. So it's a continuation of what I had read at page 38,
Yes,
right?
there's a message
Okay.
that comes in at 12:43.
Yes. How do I get involved and finish? Wish I knew what to do exactly. Yes, what about it? That's Mr. Mokgotsi saying to Mr. Chaskalson, right? And in the way that it's presented on this page, it is a response to Mr. Chaskalson saying, I think so too, but you can't mess me around. And we have discussed that in context, it must have meant this. And then Mr. Mokgotsi says, how do I get involved and finish? Wish I knew what to do exactly. That's Mr. Mokgotsi. It's not Mr. Chaskalson. What are you saying about it?
I agree.
And I asked the question, keep in mind my conversation with you is about what do you say Mr. Chaskalson did wrong in this communication that is initiated by Mr. Mokgotsi to give information about Mr. Karim to Mr. Chaskalson. And here he offers, he again continues, Mr. Mokgotsi, to offer, how do I get involved and finish? Wish I knew what to do exactly. What do you say Mr. Chaskalson did wrong when you read this text? That creates a basis for the complaint and for fear of bias on his part.
Commissioner, with the last response, in the WhatsApp message, my submission would be the navigation of whatever it is that Mr. Chaskalson and Mr. Mokgotsi were doing was being steered by the direction of the evidence leader, if I may so put it.
Where do we see that?
He asks, Mr. Mokgotsi asks, he says that, how do I get involved and finish? I wish I knew exactly what to do.
Why do you say this text was steered by, and you have to give us facts, remember? You don't get to say whatever we want. You are making allegations of fact. So when you say this text, how do I get involved and finish? Wish I knew what to do exactly. When you say this was steered, to use your language, by Mr. Chaskalson, you have to refer us to the source of that steering.
Commissioner, paragraph 6.3 of the founding papers, page 12.
That is the press conversation.
It's 6.3.
It's 6.3, Commissioner. It's page 12 of the bundle.
Yes.
Commissioner, Mr. Mokgotsi, may I just read this paragraph? On the 9th of March 2026 at 20:56, I attempted to call Advocate Charles Carlson SC, who returned my call. The call lasted approximately 3 minutes. During the call, he told me, "Get me anything against Suleiman and I will help you." He further stated that Suleiman had implicated me and that I should find a way to defend myself. He expressed his belief that Suleiman was lying, that Suleiman had thrown me under the bus, and that he wanted me to do the same to Suleiman.
And Mr. Chaskasin says what about it in his answering affidavit?
He denies the contents of this paragraph.
Yes. Yeah.
Now, Commissioner,
So there is a denial. Perhaps then that's when you get to address what do we do with that.
Hence, Commissioner, in response to that, I had said to the Commission that there's a factual dispute here wherein one party says, "I did," and the other says, "I did not." And then the other one says, "You did this," and the other one denies. And the difficulty with that, as I had answered the chairperson, is nobody knows the contents of the phone calls and what was discussed between the evidence leader and Mr. Mokgotsi.
Thank you, Ms. Mohammed.
He says, Commissioner, the evidence leader says that he's got no detailed recollection of what was discussed in the call on the 9th of March, as opposed to the call of 3 minutes past 8 in the morning of the 10th of March. It's not a denial per se. He says that he has no recollection, so he is not disputing that.
Right, I've heard you.
Ms. Mohammed, only 2 issues from me. Good morning.
Morning, Commissioner.
The transcript of 10 March 2026, when Mr. Karim was here giving evidence on page 159 and 160.
On which page, Commissioner?
159 and 160. You'll see on page 159, line 22. Because if you recall, Mr. Karim's evidence was public. He was sitting here with us. Mr. Chaskalson says, "Now, did Brown ever meet with you and Mr. Maumela?" Mr. Karim says no. Mr. Chaskalson continues, "You say no because after your evidence yesterday, Mr. Mokgotsi called us up and said he had in fact met with you and Mr. Maumela shortly after this tender. You have no recollection of that." And it continues. And the point I'm making here is it was not hidden that Mr. Mokgotsi had approached the evidence leaders and had given them evidence relating to his interactions with Mr. Karim, which is what that was all about. So if that is what has happened, how does that create a perception of substantive unfairness that should result in the evidence leader being disqualified from leading further evidence? Because there's no suggestion anywhere that what the evidence leader sought was false information from Mr. Mokgotsi. If Mr. Mokgotsi has information which is the truth and can be verified and corroborated through other means, what is wrong with evidence leaders asking Mr. Mokgotsi to provide that information so that it can be put to Mr. Karim? I would understand if you were saying in your application, evidence leaders asked Mr. Mokgotsi to provide false information. And I emphasize false information because that would be problematic to me. But if in their engagements they said, "Give me what you have on the issues we are dealing with so that I can put that to Mr. Karim," and he'll have the opportunity in a public hearing to respond to that. What is wrong with that? And how does all of that rise to the level of substantive unfairness that should result in an evidence leader being disqualified?
Commissioner, as I had previously responded, if that aspect is taken in isolation, and the only issue is that Mr. Mokgotsi approached the evidence leader, then it's the correct position. There is no basis to have the evidence leader recused specifically with regards to Mr. Mokgotsi. Now, if as the events unfold and the conversations and the interactions, Mr. Mokgotsi starts feeling that in the absence or the failure to provide or to throw Karim Suleiman under the bus doesn't work out, then he's got a problem moving forward. And that is where the inclination of biasness comes in. When he approached the evidence leader, it was done bona fide in the hope that he has information that can assist the evidence leader.
And if that information has the effect of throwing Mr. Karim under the bus, if that information is true, what is wrong with that?
Commissioner, there is nothing wrong with that, hence the establishment of the commission.
Because it is Mr. Mokgotsi who says, the very first text, he says, this guy is trying to take me down on page 35. It is Mokgotsi who's saying that. So if he has information that has the same effect towards Mr. Karim, but that information is true or can be corroborated in other means, and he's not being asked to lie to the commission or give false information, what is wrong with that? Because I can tell you in this commission, almost every every witness who comes here implicates other people. So if Mr. Mokgotsi has information that implicates Mr. Karim, and that has the effect of throwing Mr. Karim under the bus, what is wrong with that? Because that's what witnesses do in this commission. They give information, and if it is helpful to the commission, it must be put to Mr. Karim so that he's given the opportunity to dispute it. So I don't understand how that can result in substantive unfairness, which should disqualify an evidence leader. And if you respond to that, that's all I had to raise with you.
There is nothing, Commissioner, untoward about soliciting information that can assist the commission. And so to put it, even go as far as throwing Mr. Karim under the bus. The core or the challenge here is Mr. Mokgotsi alleges that he was promised. He says, I'm promised protection, I'm promised indemnity, and if I do it, I might just get out of this unscathed. There's a promise.
It's commissioners who decide what happens to Mr. Mokgotsi and other people who are implicated. It is not the people who lead evidence. Their job is to present the evidence to the commissioners, and the commissioners decide what happens to all the people who are implicated. It's not the other way around. Thank you, Chair.
I'll agree with you, Commissioner. That is indeed the hierarchy of powers and decision making. But there's an influence of some sort. It's undue influence to say, help me, then I can do this for you.
Moment.
Thank you, Commissioner.
Can we just be clear? And because this is very important, and I think I must insist that you refer us to the record. In your exchange with when I say record, I mean the papers. In your exchange with Commissioner Khumalo, you say Mr. Mokgotsi says, if I do this, I may come out of the commission unscathed. That's a promise. Can you point us in the papers where Mr. Chaskalson says that? Because that's quite a serious allegation that is being made. And if it is not in the papers that you have put before us in your application, I'm going to ask that you withdraw that allegation because it's quite a damaging allegation. Where do we find in the exchanges between them where Mr. Chaskalson says to Mr. Mokgotsi, if you give me information about Mr. Karim, I will make sure, I promise you, that I'll help you to come out of the commission unscathed. Where do we find that?
I think the best you can do is 6.5 on page 13. Also 6.16 on page 16, but it says the same thing as 6.5.
I was looking at 619.
Yes.
I see the 6.5 that Commissioner is referring
So it's
to.
6.5 where he says, I was left with a distinct impression that my protection from adverse findings by the Commission was being made conditional upon my willingness to provide information and documentation.
So my question is, point us to the exchanges between Mr. Chaskalson and Mr. Mokgotsi, where that promise is recorded. I don't want to be referred to Mr. Mokgotsi's impressions. And I want you to say, if it's not in the exchanges, if it's not recorded in the exchanges, I would like you to at least admit that for the record, that nothing in the exchanges between them that are placed before us by Mr. Mokgotsi records that.
Commissioner, I'll respond by saying that with the WhatsApp messages and the phone calls that have been put as annexures, there's nothing in that communication that brings that sort of message across. Now, it's information that comes from Mr. Mokgotsi, and it is then where he says in the affidavit that I can get out of the commission, I can be protected, and in a nutshell, I'll submit that it's some form of immunity. That's how he understands it. But further thereto, there's nothing in the communication that has been put forth that depicts that.
So just to be clear, you accept that there is no evidence before us, and Mr. Mokgotsi doesn't say, Mr. Chaskalson promised me that if I give him information on Mr. Karim, he will ensure that I come out of the commission unscathed. Nowhere in the WhatsApp messages, Mr. Mokgotsi doesn't say in any of our calls that was said, and he doesn't allege that in the affidavit. He simply says, I got the impression. I got the impression. That's what you're saying. So
yes,
where you earlier said a promise was made to him, that was not correct to say.
That is not the. I'll retract that and I'll say an impression. According to the affidavit of Mr. Mokgotsi, an impression was created.
Yes. My difficulty with you when I started engaging, why I engaged you on this, is you said a promise was made to him.
I'll retract the use of the word promise, Commissioner.
No, you're not retracting the use of the word promise. You are retracting a statement that says Mr. Chaskalson made a promise to Mr. Mokgotsi because we don't have evidence of that promise. That is what I'm saying should be retracted. you can still say, Mr. Mokgotsi says he gained the impression from their communication that that is what was being offered to him. I don't quarrel with it being an impression that he formed. The question is whether that was a reasonable impression based on the facts that are before us. The one that I needed clarity on is where you make the positive statement that he was made a promise that he would be protected from adverse findings if he gives dead or incriminating evidence on Mr. Karim. That's all I wanted you to.
Commissioner, I'll retract the statement that I made earlier on.
Thank you. I think that's a fair resolution to my concern.
Just one very brief matter. There appears to be a suggestion of something negative about the statement relating to throwing under the bus. Did I understand that correctly? If I did, can you again just articulate that?
Is the chair asking
The
my
issue
personal
about-
understanding of throw under the bus?
No. What exactly are the allegations and what is the point being made in that regard? My sense may have been wrong. My sense was that there is a suggestion that there's something negative or sinister around that issue, the issue of throwing under the bus.
Chair, it would be defend yourself at whatever cost, if I may put it in a nutshell. Chair, it says, paragraph 6.3 says that it will be on page 12 of the bundle, Chair.
Yes.
And I'll leave the first 3 lines because I believe that we had gone to this paragraph on numerous occasions, and I'll go straight to the point. Mr. Mokgotsi says that the evidence leader says that get me anything against Suleiman and I will help you. He further stated that Suleiman had implicated me and that I should find a way to defend myself. He expressed his belief that Suleiman was lying, that Suleiman had thrown me under the bus, and that he wanted me to do the same to Suleiman.
I will not engage you on get me anything against Suleiman, and I will help you because my colleague Commissioner Baloyi has already engaged you on that. I just want to take you to page 253 of the record. That comes after the affidavit of of Tsepo Modimohale. Yeah. Page 253.
I've arrived there, Chair.
Yes. Now, this is, you'll see the text by the chief evidence leader. It's written to the 2 investigators that I referred to earlier.
Yes, Chair.
And the chief investigator greets them and then says, Mokgotsi has been calling me non-stop. That again emphasizes the point I made with you, that the person who was really seeking out the other was Mr. Mokgotsi and not the other way around. Mokgotsi has been calling me non-stop since Karim started giving evidence and threw him under the bus. So the chief evidence leader has no qualms about saying that. That's his assessment of the evidence. What we will make of it is something else, of course, but that's his assessment of the evidence, and no qualms at all about saying this. He wants to give us dirt on Karim and ostensibly wants to tell us what he knows about Madlanga's contract. I've arranged to see him tomorrow at 10. If you are available, please join me. All innocent. so far as I read this. And of course, the 10 o'clock meeting is the meeting that did not materialize. Mr. Mokhodzi did not show up. And after contact was revived, an arrangement was again made, as Commissioner Baloyi said, for a meeting at 2 p.m. of the same day. That too did not materialize. Nothing negative at all in any of these. You may comment if you want to.
Chair, my comment will be, I concede with what the chairman says. If this text is read in isolation, then, Chair, there is nothing untoward.
I will not go back there because, again, Commissioner Baloyi engaged you on what more do you want us to look at, and I'm not sure that I heard what you were saying in response to that question by Commissioner Baloyi. So the same applies here as well. Your point about in isolation, but what's the additional material that you have in mind? I'm not asking for a response. The question was asked and was responded to. I'll leave it at that. And as I said, I had personally reached a point after engaging you for a longish time to hear you out. That is, to give you an opportunity to argue your case. Of course, it doesn't mean that we will not ask you questions here and there, but we want to let you feel free to argue your case. I see that the time is 4 minutes to 11. Go back for a few minutes. Yeah. Let's continue until 11 o'clock.
Chair, I do not have a response. I'm uncertain if there's any.
No. I'm not asking for a response to any question now. I want you to argue your case. We engaged you right from the start and did not really give you an opportunity to freely argue your case. I'm now giving you an opportunity to freely argue your case. Am I making sense?
You are making sense, Chair.
Unless you are saying through our engagement you've dealt with all the points that you wanted to deal with and that you have no further submissions to make. I'm not steering you in that direction, no.
Chair, I'm going to request that we take an adjournment. I'm informed that client is here so that we can obtain further instructions with what has transpired. I'm uncertain how much time the commissioners would like to give us.
All right. Well, of course, in an application brought on affidavit, I'm not sure what a litigant may tell you as to what happened or did not happen, because we go by what's contained in the affidavits. But we'll adjourn, and you can take whatever instructions you want to. Let's adjourn and return at 11:25.
Good morning again. It's 11:24. We are ready to resume. Please make sure that your devices are on mute. Thanks so much.
Yes, Ms. Mohamani.
Thank you. I have a couple of submissions to make. If I'm allowed, may I direct the Commission to page 12, paragraph 6.1 of the founding affidavit of Mr. Mokgotsi. Chair, paragraph 6.1 gives a picture of what happened when Mr. Mokgotsi reached out to the evidence leader. And he says that it was around that time he did not have any attorneys, which coincided with the time that Mr. Suleiman was giving testimony in the commission. Now, he also, further in the next paragraph, says that there was an exchange of WhatsApps and telephone calls, and the content of the conversations caused him grave concern regarding the evidence leader's impartiality. Now, it goes on and he explains what then transpired. What is important, Chair, is that with regards to the call that took place on the 9th of March, the response from the evidence leader is that he does not have any recollection of what the content of the conversation was about. And therefore, it cannot be that what he says is most probably true as opposed to what Mr. Mokgotsi is saying. Mr. Mokgotsi gives a thorough explanation as to what was discussed when the call took place, and that is the evidence that we have before the Commission, and it's not disputed. Now, Chair, I also submit that it's important that we visit the purpose or the rule of one being an evidence leader when it comes to commissions. The evidence leader's role is crucial in its nature, in that it will decide how the evidence is tested and it will shape the lines of questioning. And it ought to be done in a way that can assist the Commission, and it also impacts on the fairness of the procedure. The evidence leader can influence the narrative of the evidence, and he's the one who engages with the witnesses in order to solicit evidence from them. Now, Chair, the test for what constitutes apprehended bias is whether a reasonable, objective, and informed person would reasonably think that the decision maker or relevant actor...
Are you going back to that test now? Because I thought right at the beginning you and I reached a stage where we agreed that that's not the correct test, and that test applies to decision makers, and that an evidence leader is not a decision maker.
I'll retract.
Yes.
I'll retract that statement, Chair.
Without interrupting you, because you're dealing with an important point. The evidence leader does not say he does not recall that phone call of 2056 on the 9th of March 2026. On page 82 at paragraph 17, this is what he says. I have no detailed recollection of what was discussed. And then he continues, but in paragraph 19 on page 83, he then sets out what was discussed. And you find that on paragraph 19, he says, in our call at 2056 on 9 March 2026, this is what happened, and goes into detail about that. And then on 84, paragraph 23, he says, I would never have encouraged Mr. Mokgotsi to give false evidence against Mr. Karim. I categorically deny. Then he sets out the denials. And then he says the impression Mr. Mokgotsi's bill is trying to create, where reference is made to help, deals with that in paragraph 24. So he doesn't say he has no recollection of the phone call. So that's the full answer to that. So maybe you can then continue with your submissions. I just wanted to draw your attention to what the affidavit actually says. But by saying he doesn't have a detailed, it's based on a limited recollection.
Commissioner, the evidence leader says in paragraph 17 that he does not have a detailed recollection, meaning that he cannot recall specifics regarding the contents of what was discussed on that day. And Mr. Mokgotsi then says, I called the evidence leader, and the evidence leader suggested that based on the evidence that Mr. Suleiman gave, he threw me under the bus and I need to defend myself. That in itself is a dispute of fact. He says in paragraph 6.3 that the evidence leader asked him to get anything against Suleiman and he will help, and that Mr. Suleiman had implicated him and that he should find a way to defend himself. And further that Mr. Suleiman was lying. Now these are two conflicting versions of what the contents of the telephone call are that took place on that day. And my submission would be, in light of the absence of a detailed recollection, then what would be of sense is that Mr. Mokgotsi's version as to what was said on that day should be the one that stands.
There's a specific denial in 23.2. I deny that I suggested that if he could find evidence to implicate Mr. Karim, I would protect him from adverse findings from the commission. So that is a specific denial, and it goes to the very issue you are raising.
You in one breath, Commissioner, say that you don't have a detailed recollection, and in the same papers you say that you deny. How do you deny something that you cannot recollect in detail?
But that's a simplistic approach. Let us take the example of a person and their child. And the child says that on the 26th of April 2021, I had a discussion with my father about issue X. The father says, because of the time that has since elapsed, I do not remember that conversation. But there is no way, with the parenting skills that I have and the values that I cherish, that I could ever have said something like this to my child. I would never, ever. The parent knows what the values they cherish are. The parent knows what they could never, ever say to their child on the basis that it would be at odds with their values. So the parent, even if they do not recall the conversation referred to by the child, is in a position to say, I could never ever have said anything like that to my child. I see nothing wrong with that at all. And that's basically what, in substance, of course, that's what Commissioner Khumalo is drawing to your attention. So the chief evidence leader is saying, whatever the detail of the conversation might have been, there is no way that I could ever have said to Mr. Mokgotsi, do the improper. I see nothing wrong with that. He may not remember the detail of the conversation, but suggesting to Mr. Mokgotsi that he should do something improper, he says, that I could never ever do. So I see nothing wrong with that. And your point about him in one breath saying this and in another breath saying that does not necessarily apply or necessarily make sense. Do you follow my point?
I hear you, Chair.
Yes, yes. I had said we would try to, or rather not to interrupt as much as possible, but sometimes we cannot resist it because of the submissions being made, because we want to give you an opportunity to argue your case as freely as possible. Yeah. Please continue.
Thank you, Chair.
I'm no longer inviting you to respond to what I said. I just want you to continue with your submission.
I'll do so, Chair.
Yes. I think before Commissioner Khumalo put a question to you, you were at a point where you wanted to deal with the role of an evidence leader in instances like these. I thought that's where you were. And I sort of assumed that perhaps you were going to take us to what Justice Nugent said in the SARS Commission or something like that. Maybe that's not what you had in mind, but once you started saying something about that role, I thought of what Justice Nugent said in the SARS Commission, in his judgment in the SARS Commission.
I will revisit. I will revisit that, Chair. I deviated from my chain of thought. I'm just recollecting. If I may be so permitted, Chair, may I take the commissioners to page 21 of the bundle? It's still the founding affidavit of Mr. Mokgotsi. and this commissioners will be in reply to the selective evidence that the evidence leader deals with, and this is the basis for the fear of where the bias might emanate from. If the commissioners look at paragraph 10, the applicant makes a reference to credible information that he had made available to the evidence leader and the leads thereto. And his take is that these issues, which he sees as important issues, have not been given sufficient investigative attention. And what is happening is that the interest has been directed towards specific individuals, and in brackets, it reads Suleiman. And further thereto, there's also evidence that came to the commission regarding the purchase of certain properties in the name of private individuals, and that has also been overlooked. And he further requested that these leads that he gave be given sufficient attention. And his take is that the individuals are not as significant or as important as this evidence that he has brought forth. Further, commissioners, there's a point in limine that was raised, and this the commissioners will find at page 260 of the bundle.
260.
260, Chair.
Maybe before you start on 260, can I just to make sure that I understand what is this, the submission or the argument about paragraph 10, are you saying, is Mr. Mokhotsi rather saying that the failure, there is a failure, firstly, one, there's a failure by, is it the evidence leader, because this is an application to recuse Mr. Chaskalson, by the evidence leader to pursue his allegations that crime intelligence has brought properties, crime intelligence transactions, his evidence about a section 252A operations, informant-related issues, and procurement irregularities. Is the case being made that Mr. Chaskalson has failed to investigate those, and that failure has created an apprehension that he is biased against Mr. Mokhotsi? Is that the...
That is the position.
Okay, all right, thank you.
Please continue.
I apologize. I was directing the commissioners to page 260 of the bundle, and this deals with a point in limine that were raised by the applicant in the application for recusal. Specifically, it deals with the answering affidavit that was deposed to by the attorney purporting to be acting on behalf of the second respondent. There is no dispute that the attorney may be authorized to act on behalf of the commission. The dispute here is that the attorney goes beyond the scope of the institutional representation and purports to make factual averments on behalf of the first respondent, defend the personal conduct, intentions, and state of mind of the first respondent, who's the evidence leader. And they respond to allegations concerning private communications between Mr. Mokgotsi and the evidence leader. This attorney does not allege nor annex any proof that he or she has been authorized by the first respondent to depose to the factual matters on his behalf. The allegations that are raised against the first respondent relate to private WhatsApp communication, telephone conversations, alleged discussions, and alleged assurances of help or protection. The first respondent's subjective intentions and conduct, those are matters that are peculiarly within the personal knowledge of the first respondent. And the deponent, who is the attorney, will not be privy or cannot comment on these issues. Now, the affidavit of the first respondent has also been presented as an annexure. And there's certain value between an affidavit and an annexure. An annexure is merely a supporting document. And the attorney cannot make a case for the evidence leader and have the evidence leader's affidavit come in as an annexure, which seems to be confirming submissions by the attorney for the commission. I'm inviting the commission to find that when it comes to the affidavit that was deposed to by the attorney for the commission, that the commission finds that that affidavit does not enjoy locus standi. The issues that are contained in that affidavit and the comments cannot be of any value or any benefit because it's comments that they know nothing about. It's personal communication between Mr. Mokgotsi and the evidence leader. And it's issues that the evidence leader should be answering and not the attorney. Commissioners, there has been an explanation that was proffered in the replying affidavit regarding these deleted telephone calls or emojis. Now,
I'm sorry. Please don't forget the point
where I was, yes, Chair.
you were about to make. In the context of hearing the testimony of a witness, and in fact, even beyond that, the applicable prescripts say that the rules of evidence that apply, for example, in courts of law, do not apply to commissions of inquiry. Commissions of inquiry may receive evidence of variety of forms which would ordinarily not be admissible in courts of law. But as I say, that's in the context, or that's provided for in the context of the commission receiving evidence towards the investigation that it was set up for. That's the context. Would you say that those rules with regard to the admissibility, acceptance of evidence would not apply to an interlocutory process like the one we have before us now? You would have that permissive manner of receiving evidence in the context of receiving evidence towards the investigation. but have a very restrictive process when it comes to interlocutory matters that relate to the Commission's investigative process. I'm asking that in the context of the point in limine that you are raising. Wouldn't there be an anomaly if that were to be the case?
Chair, in the normal route, that would be an issue to raise. However, in light of what you are saying to me or what you are putting to me, I'll submit that in a quasi-judicial tribunal like of this nature, then I cannot take that point in limine any further if that is then the status quo. I will have to leave that point in limine and not argue it any further.
Thank you. I did not want us to reach a situation where, for example, we decide your point in limine along the lines of what I've raised with you without offering you an opportunity to respond. Well, I have offered you that opportunity and you have responded. You may go back to the point I asked you not to forget.
Oh, yes, Chair, thank you. Chair, I was making a submission with regards to the deletion or the alleged fraudulent deletion of conversations in the WhatsApp records. And I was further saying that Mr. Mokgotsi did respond to those allegations that were put forth by the evidence leader. And at paragraph 41, which will be at page 267 of the replying affidavit,
Yes.
Mr. Mokgotsi says that he admits that he deleted the message dated the 11th of March that was sent at 11:29 a.m. And the intention was not to mislead the Commission, as at the time he had not even contemplated bringing the application here in. He further says in the next paragraph, the sole intention behind the deletion was to protect my conversation with the first respondent from third persons. The next paragraph, he says that he admits that he deleted the calls on the basis that at the time of taking the screenshots for purposes of this application, he did not find them relevant. And furthermore, he's further to allow me to take screenshots of the relevant facts. I therefore deleted them. I understand this, Chair, and I'm subject to correction to say that to allow me to take screenshots of the relevant facts, his headset doesn't allow him to take screenshots. I'm uncertain how to read this, and I seek the guidance of the Commission.
No, just make your submissions.
I submit that.
There's no need for guidance from us on this.
I submit that, and subject to correction, that his handset did not allow him to take screenshots of the relevant facts. He therefore deleted them. The calls that have been deleted were unanswered and therefore hold no significance to the application.
Except, of course, that they may assist in the context of what I engaged you on right at the beginning. I will not repeat that. Please continue.
Chair, what
That
is...
is the point I made about, based on the number of calls, who appears to have sought out whom in that context. Please continue.
Chair, what is common cause? Is that, yes, there was communication between Mr. Mokhotsi and the evidence leader. And during those conversations, a discussion came in regarding Mr. Karim. It's also common cause that during the conversation, there was an agreement or a request to bring certain evidence to rebut what was put on record regarding Mr. Mokhotsi, to defend himself, and if the need arises, to throw Mr. Karim under the bus. Now, Mr. Mokhotsi's evidence is that the communication between himself and Mr. Karim formed an impression that his cooperation in providing information against another witness was linked to his treatment in the proceedings. And this, Chair, will find at paragraph 7 of the replying affidavit. And he further says that whether intended or not, such perception undermines the appearance of impartiality. Now, it goes back, Chair, to whether or not a reasonable, objective, and informed person would apprehend bias. Now, with what had transpired and with Mr. Mokhotsi due to come back to the commission and testify, and him not being able to have provided any information that was helpful because the meetings never happened, he became fearful of appearances of impartiality, and that he would, upon his appearance, be treated unfairly.
Mama, is it not opportunistic to offer Mr. Chaskalson information on Mr. Karim and then fail to deliver because Mr. Mokhotsi turns out doesn't have that kind of information, and then say, I fear that Mr. Chaskalson will be biased against me because I did not give him that which I promised? Isn't there some opportunism there? You offer, and then you fail to deliver, and then without more, you say, he's going to be biased against me. I mean, he hasn't referred us to anything in the chats which shows Mr. Chaskalson being upset with him or saying to him, you know, I'm going to get you for failing to deliver. There's none of that, other than that text which we have read in context, that it actually doesn't quite convey what you were saying, where it says, don't mess with me, don't mess me around, or something like that. I don't understand how that an offer made which couldn't be fulfilled without more creates a reasonable, remember the test is reasonable apprehension of bias, how that would create a reasonable apprehension of bias that after this he's not going to treat me fairly.
In response, Commissioner, what we had considered is that Mr. Mokhotsi is the one who called the evidence leader. That is not in dispute. However, what was contained in the phone calls, and I had said previously, I do not know, and neither does anybody know what was discussed in these telephone calls.
Then in that case, how can the commission say the apprehension is reasonable if we don't know what was discussed in those calls? You're saying that we don't know, therefore we don't have the content of those telephone calls according to you. So we lack the necessary facts on the basis of which the commission can make the determination that the apprehension is reasonable, because eventually that's what we must find. We must find that the apprehension is reasonable.
Commissioner, firstly, I'll invite the commission to make a finding through what is contained in the papers. Now, what seems to be a challenge is that with regards to the telephone calls, there's a dispute of fact. One says, I said, the other says, I said. Hence, I keep on repeating that I do not know what was contained in the telephone conversation. And Commissioner, you would also not be in a position to know what was discussed in those telephone conversations. And unfortunately for me, there is no recorded conversation of what would have happened. I will rely on the submissions that my client makes before the commission. Now, I had said previously that he's labeled as a liar. He was labeled as a liar. Now, if he approaches you, this liar, and he says, I've got information, why would you be interested in information? He might be lying to you.
I wasn't taking you back to that conversation. I was really addressing your submission where you say, we don't know what was discussed. You don't know, the commissioners don't know what was discussed in those telephone calls. That comes from you, it's your submission. So I was asking the simple question that if we don't have the facts about those calls, what was discussed, are we in a position, at least as it relates to those calls, is the commission in a position to make a determination that what was discussed in the calls creates a reasonable apprehension of bias? That's all I was putting to you. And maybe to reframe it, maybe can I ask you this? Do you accept that for a determination that the feared bias is reasonable, for that determination, there has to be facts on which that determination is based? Facts must be put to the panel, and then the panel will say, yes, on these facts, we are satisfied, or we are not satisfied that the apprehension of bias is reasonable. Do you accept that as a proposition?
I'll accept it, Commissioner.
You accept that?
Yes.
Right. So on the back of that, I then ask the question, if we don't know what was discussed in the calls, insofar as it relates to the calls, limit it to the calls for now. If we do not know what was discussed in those calls, as you say, can you accept, should you not accept that the commission is not, the panel is not in a position to say those telephone calls do create a reasonable apprehension of bias, because we don't know what was discussed according to you? Do you accept that we cannot make that determination?
If the Commissioner allows me to reply to that in two parts.
Yes.
On the first aspect, Commissioner, you are correct. in the absence of us knowing or the commission knowing what was contained in those telephone calls, the commission cannot rule on the apprehension of harm or of
Arising
bias.
from the calls, yeah,
Or
just
of
arising
bias,
from
yes,
the
I
calls.
apologize. But then there's two sides and two versions, if I may so put it, of what was contained or what was discussed. And based on those, and based on how the applicant perceives in his mind what the contents of these discussions are, then the commission can be in a position to make a ruling as to whether or not there is an apprehension of bias. Now, Commissioner, I submit further that the issue here is not that Mr. Brown doesn't come back and give testimony in the commission. The issue here is somebody else in the commission may be elected if there's an election procedure or appointed if there's an appointment procedure to come on board and move with the cross-examination.
How much more time do you require, Ms. Mohomane?
On the submissions.
Yes. Your entire submissions. We started at 9:30. Now it is 6 minutes after 12 midday. If I was sitting in the court where I used to sit, we would have given you 30 minutes only. I'm listening. That doesn't mean I will accept the time that you.
Chair, I won't be longer than 5 minutes.
Thank you very much. Thank you.
Chair, lastly, I request to invite the commission to the role of the evidence leaders. I believe I left it hanging, and I had said to the commission that I will come back to it in due course. Now, to supplement what I had said previously, in a nutshell, evidence leaders are required to assist and facilitate the work of the commission. And in doing so, they must investigate and marshal the presentation of evidence to the commission. They bear the overall responsibility of leading evidence before the commission, although it is subject to the direction of the chairperson. If I'm so permitted, may I direct the court to the matter or the ruling by Judge Nugent in the Commission of Inquiry into Tax Administration and Governance by the South African Revenue Service.
You don't need to read that. We have had sight of it. We have read it. Yes. Please continue. But of course, you may make whatever point you want to make about it.
Chair, we do not have any further submissions to make unless the Commission would like me to address it on other aspects.
No, thank you very much, Ms. Mohomane.
Thank
you. Yes, Ms. Asim.
Thank you, Chair. Chair, I've listened closely to the exchanges between the commissioners and my learned friend, Ms. Mohamane, and to some extent it covers ground that we had included in the answering affidavit submitted to the Commission, including some of the legal submissions we made there. So I beg the Chair's indulgence if I come back and touch on the same issues that arose in the exchange, but I hope to give it a proper perspective in my address to you. And to begin with, Chair, let me just say that the evidence leaders oppose this application in the strongest terms. And obviously we submit that the application should be dismissed. And we do so on the basis that it's legally misconceived. And I have heard the shift in approach by my learned friend and the reference to Killian earlier, but I'll submit in due course that there wasn't actually any shift in an argument and the legal basis, the wrong legal basis that was advanced. So it's legally misconceived. On the facts, it's not just unsustainable, it's a deliberate misrepresentation of the facts. And I propose to return to the facts in order to explain this. And it's an abuse of the Commission's process. Chair, I will address 4 issues. The first, the conceptual flaw. The second is the factual basis of the application. And I would like to have a particular focus on the altered WhatsApp record that was put forward by Mr. Mokhotsi as a key part of the basis, the factual basis for his application. Third, the allegation of unfair questioning by Mr. Chaskelson. And finally, what we respectfully submit should be the appropriate ruling in the circumstances, including referrals for investigation for possible perjury, forgery, and contraventions of the Commissions Act and the regulations of this Commission. So the first difficulty, as I said, is conceptual. Mr. Mokhotsi invokes the law of judicial recusal. He relies on Safu, on De Lacy, on Besson, on Burnett, and Mulaudzi. All of those cases concern judicial officers or decision makers. None of them concern a commission of inquiry or even something akin to a commission of inquiry. And while my learned friend indicated reliance on Killian at the start of her submissions to the Commission, she continued to make submissions on the basis of a reasonable apprehension of bias, the test for judicial recusal. And that's not the test that applies, because Mr. Chaskelson is not a decision maker. He doesn't decide credibility. He doesn't decide admissibility. He doesn't make any decisions about whether adverse findings should be made, when and how. Those powers belong to the Commission. What an evidence leader does, as correctly asserted by my learned friend, is an evidence leader assists the Commission. He leads, organizes, and tests evidence. That function must be performed fairly, but it's not adjudicative. It's an investigative function. To assist the Commission, we've provided the authorities that we think are more suited to an application of this sort, where an applicant is seeking to remove an evidence leader. And in this regard, Chair, we refer to the recent ruling of Justice Khampepe in the TRC Commission. And it was specifically an application that was made there too for the recusal of an evidence leader. And what she said is important. The chairperson rejected the proposition that the SAFU recusal test applies directly to evidence leaders. Her ruling held that evidence leaders are not decision makers. They function always subject to the direction of the Commission. The appropriate inquiry, therefore, by analogy perhaps with that of prosecutors, is whether the evidence leaders' continued role would cause substantive unfairness in the work of the Commission. And that approach is consistent with the decisions in the two cases that we've referred to in the answering submissions, Porritt versus NDPP and DPP Western Cape versus Killian. In Porritt, the Supreme Court of Appeal rejected an attempt to equate prosecutors with judicial officers for the purposes of recusal. And in Killian, the same reasoning was applied. And in Killian, the issue there was whether the prosecutor should be removed because the prosecutor was the same person that had interrogated the applicant for recusal, had interrogated that person in an earlier statutory inquiry. And so there were serious concerns about whether there would be fairness on behalf of the prosecutor in that case, and the Supreme Court of Appeal rejected that argument. So the question is not whether the SAFU recusal test is satisfied, it's whether the continued involvement of the evidence leader would cause substantive unfairness in the Commission's work. Mr. Mokgotsi has not shown that. Now, incidentally,
if the allegations made were true, would the test not be met? I'm not asking whether we should hold that they are. That's a debate we're still engaging in, and that's a finding we will make in the end. But if they were true, would they not meet the test?
Chair, the allegations are so serious. They go to the heart of ethics, professional ethics, and the integrity of the evidence leader. Those kind of allegations, if proven to be correct, would warrant a conclusion that there's unfairness. They're very, very serious allegations, and we take it very seriously. But of course, I'm about to...
It's something else whether
yes.
They are in fact true, and that's what you're going to deal with, and that's what we engage Ms. Mohomane on.
Indeed so, Chair.
Yes.
So, and that rests on the facts that
yes.
support this application.
Yes.
Chair, I actually wanted to say on the law, incidentally, in paragraph 40 of the submissions of the attorney for the Commission, Mr. Mokgashwa, paragraph 40, it's pointed out that it's not just that the cases don't apply here because the test doesn't apply. There are quotations that are attributed to those cases which are not found in those cases. I just make it as an aside. For a moment I thought whether I should even say anything about it, and then I've rethought. And actually it is important because it is the responsibility of counsel who appear before any tribunal to ensure that the correct law and that is put to a decision maker. And whether or not the papers were settled by the legal representatives were very aware after reading our answering affidavit that was a concern, but it's just not addressed at all. And I just wanted to make that point because one needs to be able to rely on quotations as genuinely existing in the cases that I cited. I leave it at that. I don't want to take it any further. So much for the law and the cases, and the legal basis of Mr. Mokgotsi's application. Let's turn to the facts. There are two main factual propositions.
Maybe before you do that, the other point that has been taken, and you didn't list it in the topics that you're going to be addressing, is the standing of the affidavit of the attorneys for the Commission.
Yes.
And its consequence for Mr. Chaskalson's affidavit.
Yes, thank you, Commissioner. I think that the point is more about form than of substance. Mr. Chaskelson has submitted a full, detailed, comprehensive answering affidavit on oath. It is true that is annexed to Mr. Mokgashwa's affidavit, but it's just a question of form, because Mr. Mokgashwa sets out submissions, as you will recall, at the end of the last appearance of Mr. Mokgotsi. The request was for submissions to be made by the applicant, and then for submissions to be made, including legal submissions, on behalf of the respondent. And it seemed to us, in the unusual circumstances of a commission inquiry, that this would be the appropriate form to submit it in. It's just a question of form. There's nothing that I think it's an entirely unreasonable allegation to make that there's no weight to be given to Mr. Chaskelson's affidavit, because it looks like an annexure and it's not a self-standing affidavit. His position is made very clear. He sets out the facts in his affidavit.
It says in the railway tracks answering affidavit.
And it does,
And
yes.
he says in paragraph 5, I am deposing to an affidavit. So it is an affidavit.
It's absolutely an affidavit, and moreover, he responds in that affidavit, paragraph by paragraph, to the founding affidavit of Mr. Mokgotsi.
I think what I understood to be the issue that is raised about it is Mr. Mokgashwa lacks locus standi to depose to an affidavit. That's the one part of it. And then the second is his affidavit, well, it's actually 3 points, as I think I understood them. It's the locus standi issue. And then 2, it is his affidavit contains hearsay, and then the annexure issue that Mr. Chaskelson effectively hasn't answered the allegations because his affidavit is attached as an annexure. So your exchange now with Commissioner Khumalo deals with the third part, which is, well, there is an affidavit that is before us, but the antecedent questions is locus standi, and then the second, I said it was...
Hearsay.
Hearsay. Thank you.
Well, if one reads the affidavit closely, there isn't hearsay. What one will find in the affidavit is reliance on Mr. Chaskelson's own affidavit for any factual proposition that relates to the communications between Mr. Chaskelson and Mr. Mokgotsi. It's a repeated referral to Mr. Chaskelson's affidavit. And where it goes beyond Mr. Chaskelson's affidavit, it does so with reference to the record, transcripts of this commission's hearing.
If we accepted that parts of that affidavit, Mr. Mokgashwa's affidavit, contains hearsay, can we disregard that hearsay part of evidence and yet still end up with an affidavit that deals with the other issues that are not an answer to the facts of the exchanges between the two?
Commissioner Beloy, let me have two responses to it. The first is, these are different proceedings to a court of law. How you assess the probity of that evidence is up to the commissioners. But hearsay evidence, as we know, is admissible in a commission of inquiry. That's the first thing I'll say. But let me say this too.
Does that not apply to the evidence of witnesses to the commission?
To the extent that Mr.
lower standard of how you treat evidence.
To the extent that Mr. Mokgashwa is a witness here in providing this affidavit, then the same would apply. But even if you were to disregard what you may consider to be hearsay, and I'll say again, I'll repeat again to the Commission, there's very little hearsay if any, in that affidavit. But even if there were, and you were to disregard it, the strength of this opposition doesn't rely on Mr. Mokgashwa's affidavit. the strength of the opposition relies on Mr. Chaskelson's affidavit.
Is it open to us, to the commission, to say can we do this? It's a question. We say these paragraphs contain hearsay evidence, which is what is contained in Mr. Chaskelson's testimony anyway, as you say, affidavit. So we disregard Mohashua to the extent that those parts, because to say it contains hearsay evidence, as I understand the position to be, doesn't mean we necessarily reject the whole affidavit, right? You look at what, in fact, in the affidavit is hearsay, and then you decide how to treat it.
Mm-hmm.
Could we retain Mr. Mohashua's affidavit on the basis that it places Mr. Chaskelson's evidence before us? I don't know if you understand what I'm saying. His affidavit before us, even if we disregarded the parts that we've ultimately say this is hearsay evidence. I don't know if I'm articulating.
I think I understand what you're saying, Commissioner, but I see no reason why you can't do that, even if you were to disregard large parts. And remember that that affidavit doesn't just deal with the facts, it also is here to make submissions. And to make submissions for the purposes of assisting the Commission, which is why we put to the Commission case law that is intended to set the correct legal framework for this. The approach is not to say, well, the applicants didn't make out a case, there's no legal foundation, full stop, which is what one would do in a normal case. You may not necessarily go down a long road. You'll say there's just no case that's been met here. We're in a different position. We're here to assist the Commission and to put all evidence and all law that may assist the Commissioners in making this decision. And that's the value of that affidavit of Mr. Mohashua.
And the complaint or assertion that he lacks locus standi, it's accepted that he acts by the applicant, that he acts for the institution. And so I understand the applicant to accept that he has standing to speak on behalf of the Commission, and yet there is a submission that he lacks locus standi. Do you want? I'm not sure I understand how there's an acceptance and yet that kind of complaint. Do you want to say anything about it?
Commissioner Mbalwa, I have to confess I don't understand the submission. It's very difficult for me to respond to it beyond what I've already said.
Okay. But you assert that Mr. Mohashua does have locus standi to depose on behalf of the Commission.
And to oppose the application. Yes.
Thank you.
So,
ask a follow-up question. It may or may not matter in the end. My understanding of hearsay is that it is evidence, the probative value of which depends on something which somebody else knows, but that person is not giving evidence. Now, you have a situation here where Mr. Chaskelson deposes to an affidavit which is longer than Mr. Mohashua's affidavit by some 5 or 6 pages. It's 21, Mohashua's is 17. And Mohashua says, I have read Chaskelson's affidavit, so where I deal with the allegations against Chaskelson, I rely on the affidavit by Chaskelson, which means there is an affidavit by Chaskelson. So it's not hearsay because that evidence is here, and he simply repeats then what Chaskelson says.
Quite right, Commissioner Kamalo. It really is, as I said, a repeated referral to what is said in Mr. Chaskelson's affidavit.
So if there was no affidavit by Chaskelson, then what Mohashua says would be hearsay?
Absolutely. Absolutely. It's entirely based on Mr. Chaskelson's. And in fact, he says so. Mr. Mohashua says so, that this affidavit is based on the facts, the correct facts as stated in Mr. Chaskelson's affidavit. And so the idea that, when I heard my learned
I
friend...
don't want to, I just wanted that short response.
Sure.
I
Well,
know we could argue and debate
We
this.
could go on, but I'll turn to the facts then, if I may. So the factual foundation seems to be twofold. First, Mr. Mokgotsi says that Mr. Chaskelson treated him unfairly when he previously testified before this commission, in the manner in which Mr. Chaskelson questioned him. Second, he makes what we say is a very, very grave allegation that Mr. Chaskelson induced him to give evidence, and to give false evidence against another witness before this commission. And if one has regard to Mr. Chaskelson's affidavit, it is abundantly clear from the affidavit and the annexures that these propositions are simply untenable. The answering affidavit is more than a denial, and I will call it an answering affidavit, Mr. Chaskelson's affidavit. That's what when I refer to the answering affidavit, I'm always referring to Mr. Chaskelson's affidavit. That affidavit is more than a denial. It's a detailed factual account supported by the true WhatsApp record, annexed as MC1, and a marked up comparison, annexed as MC2, which identifies the communications which Mr. Mokgotsi removed from his annexure, and his annexure is marked OBM2. I think that there was a point at which, when I say that it's more than a denial, there was an argument by my learned friend that Mr. Chaskelson did not dispute paragraph 6.3 of the founding affidavit. And it goes to, there was an exchange between Commissioner Khumalo and my learned friend. It goes to, in fact, if we could just go to Mr. Chaskelson's affidavit at paragraph 17, and that's at page 82 of the record. Because this is the one instance where the submissions for the applicant say that there is no denial by Mr. Chaskelson. And if you look at paragraph 17, so the point that's made is, well, how can Mr. Chaskelson deny that he, solicited evidence from Mr. Mokgotsi if he doesn't recall the conversation? But look closely at what Mr. Chaskelson says at paragraph 17. He says the following: I have no detailed recollection of what was discussed in the call at 20 hours 56 on 9 March 2026, as opposed to the call at 8:03 on the morning of 10 March 2026. So what is set out below is reconstructed from my overall memory of the two calls, as informed by the WhatsApp record. What Mr. Chaskelson is saying is I can't say whether I said something in the first call or in the second call, but together, these are the facts that I can set out of the conversations that took place on those two calls. He sets it then in detail from paragraph 18 and onwards, and he concludes at paragraph 23 with his categorical denials that he invited Mr. Mokgotsi to give false evidence against Mr. Karim, or that he suggested that if Mr. Mokgotsi could find evidence to implicate Mr. Karim, that he would then protect him from adverse findings. So there is simply no basis to say that there's no denial. And again, I submit that it's more than just a denial, because what Mr. Chaskelson does is set out the facts with reference to the WhatsApp record. So calls must be seen in the context of the WhatsApp record. But Mr. Mokgotzi's difficulty goes further because his own replying affidavit destroys his allegation that Advocate Chaskalson exerted improper pressure on him. He admits to manipulating the WhatsApp exchanges between himself and Mr. Chaskalson before placing the record before the commission. He doesn't use the word manipulating. He tries to explain it in several ways, but he admits to making several deletions. And one deletion he doesn't even answer to at all, and that's the emojis, which I'll come to in a moment. Chair, if I may ask that we look at OBM2, the annexure that's put up by Mr. Mokgotsi, the WhatsApp record that he puts up. OBM2 is, what page? Thank you. I don't know about, I'm not using the bundles because the printed version is not that good for me, for the submissions I'm going to make. I would ask the commissioners if you have the electronic version to look at that version, alternatively to look at what's being flighted in front of you, because it's a better version. And it's important that you see this for the following reason. The problem with this annexure is not just about its content and the misrepresentation in the content. It's also about its appearance. It's not presented as a transcript of WhatsApp exchanges that took place between the two individuals with ellipses or anything like that. It's not even presented as screenshots showing deleted messages, as one would ordinarily see in a WhatsApp conversation where messages have been removed. Ordinarily, one sees deleted message. You deleted this message, or this message was deleted. That is not how it appears. It's made to appear as a genuine and complete set of screenshots with the default WhatsApp speech bubble colors and with the default WhatsApp wallpaper. It, in other words, conceals that material texts and calls have been deleted. It's not, if Mr. Mokgotsi had put up a transcript and that indicated there were deletions, that would be one thing. So the first submission I'm making to the commissioners is, before we even get to the content of the deletions, it's the appearance that's created in this constructed set of chats that makes it look like there was nothing in between. And that's significant. The deletions themselves, too, are significant because they are material in what they show and what they don't show. They are material because they point away from the narrative that Mr. Mokgotsi seeks to create before this commission. What he says, of course, to try to explain this is that he admits, first he denies tampering with the WhatsApp messages in paragraph 38. But then he admits to deleting the message. He admits to deleting the message of 12 March at 11:29. And that's the text that says, in fact, if I may ask that MC2 is now displayed, because this shows easily where the deletions are made. So the text said, I'm worried about coming there, also mentioning that I called you at night, thought would be strategic also. He says that this deletion was made to protect the conversation from unnamed third persons. I'm not sure what it is we're supposed to make of that. He says nothing more about these third persons and why there would be a risk. Then he is silent on the text that he deleted with the 3 crying with the laughter emojis. He doesn't explain at all why he deleted those emojis sent on 10 March at 1:18 in the afternoon, and that was during the evidence of Mr. Karim. And what it was indicating was that he was sort of reveling in the discomfort that Mr. Karim was facing in the witness box. That he deletes, but he doesn't explain why he deleted it. He admits that he deleted the calls. And he says that he didn't regard them as relevant. So he deleted that from the screenshots. And he wished to capture what he considered to be the relevant facts. But to be clear, what he deleted was 6 calls to Mr. Chaskelson, which Mr. Chaskelson declined to answer. 3 calls on the 9th March, the day on which Mr. Karim first began his evidence, and 3 further calls during the lunch adjournment of Mr. Karim's testimony. He therefore doesn't merely admit to deleting, he admits to curating the WhatsApp account, the WhatsApp record rather, selecting what he considered to be relevant and presenting only part of the picture to the Commission and making it appear authentic. This is deliberately deceptive. This was misleading to the Commission. And Commissioners, Annexure MC2 sets very neatly the actual true content, because what it does is take OBM2 and then it inserts where the missing texts ought to be. And what it also shows is that if this was an authentic record, you would have seen those deletions. You would have seen that it says deleted and it doesn't say so. So those calls, those 6 calls on 9 and 10 March must be understood in the context of the backdrop of Mr. Karim's oral evidence. Because what it shows is, first of all, on 9 March, Mr. Karim gave evidence, right, about his conversations, the WhatsApp conversations that were put in the record between him and Mr. Madlanga. As Mr. Chaskelson says in his affidavit, and it's at paragraph 18.2 for the record, that in response to many of the questions that were being put to Mr. Karim regarding the WhatsApp communications between him and Mr. Madlanga, Mr. Karim sought to blame Mr. Mokhotsi for what he was conveying to Mr. Madlanga. So that was what was happening on the 9th of March. That evening, Mr. Mokhotsi initiated a call to Mr. Chaskelson. Mr. Chaskelson says, and that's at paragraph 19 of his affidavit for the record, that in his call, which lasted all of 3 minutes, in this call, Mr. Mokhotsi conveyed his concern that Mr. Karim had been blaming him for everything. Mr. Chaskelson accepts that he agreed with this assessment. That too was his assessment of Mr. Karim's evidence. And he also accepts that he may well have used the phrase throwing him under the bus. And he refers to, he puts up the contemporaneous text to 2 investigators of the Commission where he used that phrase, and speaking colloquially, he used the phrase throwing him under the bus. But it's Mr. Mokhotsi who asks, how will you protect me? Mr. Chaskelson explains this at paragraph 24 of his affidavit for the record, that he understood Mr. Mokhotsi to be asking for protection from being falsely blamed. So protection from being thrown under the bus. That's the protection that he understood Mr. Mokhotsi to be seeking. That's his explanation of it. Mr. Mokhotsi then called 3 more times that night. Mr. Chaskelson did not answer. So it's Mr. Mokhotsi that's driving this. The pursuit is being made by Mr. Mokhotsi, not by Mr. Chaskelson. What Mr. Chaskelson says is that Mr. Mokhotsi offered evidence against Mr. Karim, as well as further evidence. So it wasn't just evidence regarding Mr. Karim's testimony, but it was also evidence relating to the Medicare 24 contract that was also a subject of debate with Mr. Karim the contract that Mr. Madlanga concluded with the SAPS. And again, that explanation is corroborated by the two contemporaneous messages to the two investigators. Because when you have a look at that, those are annexed as MC4 and MC5 to Mr. Chaskelson's answering affidavit. What he says in those texts to the investigators in part is, Mokgotsi has been calling me non-stop. He wants to give us dirt on Karim and ostensibly wants to tell us what he knows about Madlanga's contract. And then he asks the investigators to join him in a meeting with the Mr. Mokgotsi that he was trying to set up the next day at 10 o'clock. They both agreed to go through to the meeting. And the plan was to go through to hear what Mr. Mokgotsi had to say, obviously, but to go through his evidence because, again, Commissioners, you may recall that Mr. Mokgotsi was due to appear before the Commission on the 13th of March. He was no longer represented. Therefore, Mr. Chaskelson needed to meet with him in order to make sure that there was preparation for that evidence on the 13th of March. It's entirely appropriate that Mr. Chaskelson did so. So the continued allegations that, well, he was trying to meet me, really is neither here nor there. There's simply nothing wrong with Mr. Chaskelson making those efforts. But Mr. Mokgotsi doesn't show up to the meeting at 10 o'clock, and he doesn't he doesn't give any indication that he's not going to show up. So then when Mr. Chaskelson calls him, the call is again very short if one has a look at the record, and it's to inquire about his whereabouts. They then agree that they'll meet at 2 o'clock. And they set an appointment for 2 o'clock, and again, Mr. Mokgotsi doesn't show up. And again, Mr. Mokgotsi doesn't answer his phone, and he doesn't explain why he didn't show up. He doesn't give an indication. In the meantime, we've had Mr. Chaskelson and the investigators waiting around for this appointment. And that's what Mr. Chaskelson explains when he says what he meant by, you can't mess me around. That's what he says, is you can't mess me around. And he explains that what he's referring to is that Mr. Mokgotsi's missing appointments was continually missing these appointments and disrupting the schedules of the evidence leader and the investigators. So that's his explanation. Don't mess me around. It makes sense when you have regard to the full context of the WhatsApp records. If you were truly, and I think it was, I can't remember which of the commissioners put this to my learned friend, but the point is important because if he were truly attempting to use false information against Mr. Mokgotsi, why would he invite the investigators to accompany him? And second important relevance of the investigators being there is so that they can follow up on any information that does emerge from Mr. Mokgotsi to test its credibility and to see whether it can be independently corroborated. Again, entirely consistent with the version that Mr. Chaskelson explains in his answering affidavit. So the true picture is this. Mr. Mokgotsi pursued Mr. Chaskelson. He initiated the conversations. He says he was concerned that Mr. Karim was throwing him under the bus. He sought assistance to avoid being used as a scapegoat, as Mr. Chaskelson explains it. That was his understanding. That's the assistance, the help he wanted was not to be used as a scapegoat. And then he offered to provide evidence against Mr. Karim and the Medicare 24 contract. But what is more, as we now know, he was also peddling falsehoods to Mr. Chaskelson. And he says so in order to precipitate a postponement of Mr. Karim's evidence. And we also see now, contrary to everything that he was saying about Mr. Karim to Mr. Chaskelson around the 9th and 10th of March, when those efforts proved unsuccessful to provide evidence to secure a postponement, he then provides an affidavit which is attached to his founding affidavit in which he lists all the parts of the testimony that of Mr. Karim that he now corroborates. And I'll come back to the false information, Chair. Let me deal with the next aspect before I come to that. The next aspect is this question of, well, you see Mr. Chaskelson was playing this false game, because on the 10th of March, when he was questioning Mr. Karim, he said to Mr. Karim that yesterday Mr. Mokhotsi told me this about a meeting that took place in the Northwest. And I really am not going to spend much time on this. It's very clear when you look at the record that what Mr. Chaskelson was saying was, he said the following: because after your evidence yesterday, Mr. Mokhotsi called us up. So he was referring to evidence that had been given the day before, not that Mr. Mokhotsi had called him the day before. So the timing of the call from Mr. Mokhotsi is actually not relevant. The material point is this. It's that Mr. Mokhotsi admits that he told Mr. Chaskelson that this meeting took place, this meeting in the Northwest. He admits that. And then he adds this following startling addition to his affidavit. At paragraph 6.10 of his founding affidavit, he says the following. He says, I began by suggesting he ask about the meeting between myself, Morgan Maumela, and Suleiman. A meeting which never took place. I did this deliberately to encourage him to postpone Suleiman's testimony, as I was already concerned about the Commission's treatment of me and its focus on issues outside its mandate. So this is the point I was making earlier. He admits that what he told Mr. Chaskelson was false in that paragraph, and that he advanced that falsehood to secure postponement of Mr. Karim's testimony. That admission is serious, because it doesn't only suggest dishonesty, but it's a deliberate attempt to manipulate the evidence leader and this Commission's process. Mr. Mokhotsi's conduct, and it's for that reason, Chair, that we say that Mr. Mokhotsi's conduct, in addition to the forged WhatsApp record, his conduct should be investigated as a possible offence under the Section 5 of the Commissions Act and Regulation.
6.20 says, I deliberately mentioned it to prompt a postponement of Suleiman's testimony, so it was deliberate.
Absolutely. He deliberately gave false evidence to secure the postponement of Mr. Karim's evidence. Those are the words that he says unmistakably in his affidavit. That brings me to the complaint about the questioning. Mr. Mokhotsi complains that Mr. Chaskelson questioned him very vigorously and put it to him that he was dishonest. That's true. That did take place. Mr. Chaskelson did question him vigorously and did say to him that he was being dishonest. But that's not unfair, because a commission is inquisitorial. It's the duty of an evidence leader to test evidence, to confront witnesses with inconsistencies, and to put adverse propositions to them so that they may answer. Robust questioning is not unfairness. In our affidavit, in our submissions, we pointed to the extract from Justice Nugent's ruling in the SARS Commission, where he speaks about the role of evidence leaders. Chair, I do think that this paragraph is important. May I read it out? And I think it's important that everybody understands the role of evidence leaders. And I'll read it very fast. What Justice Nugent said in the SARS Commission is the following. What is called for from counsel for a commission and from the commission itself is an open but inquiring mind, the meaning of which I had occasion to explain in the Supreme Court of Appeal. That case concerned the functions of the public protector, but it applies as much to a commission of inquiry. And then he quotes from the SCA judgment as follows. That state of mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it's also not one that is unduly believing. It asks whether the pieces that have been presented fit into place. If at first they do not, then it asks questions and seeks out information until they do. It's also not a state of mind that remains static. If the pieces remain out of place after further inquiry, then it might progress to being a suspicious mind. And if the pieces still do not fit, then it might progress to a conviction that there is deceit. How it progresses will vary with the exigencies of the particular case. One question might lead to another, and that question to yet another, and so it might go on. It is in that state of mind that counsel go about their work. So that the SCA, for completeness, the SCA judgment that Justice Nugent was referring to was a passage from the Public Protector versus Mail and Guardian. And the reference, if I may provide it, is 2011, Volume 4, South African Law Reports, at page 420, decision of the SCA, and the passage is in paragraph 22 of the judgment.
Is the citation not given in the affidavit?
It is. It is not.
It is not.
No, it is not, Chair. That's why I'm giving it to you now. We omitted to explain that that's where the passage comes from. The Constitutional Court cited the same principle with approval. The same paragraph 22 was cited by the Con Court with approval in Public Protector versus the President of the Republic of South Africa. And again, for completeness, let me provide that citation. It's 2021, Volume 6, South African Law Reports, page 37, decision of the Con Court, and it's at paragraph 139 specifically. That's the proper approach to questioning by an evidence leader. It does not require impartiality. It requires a probing, an open, inquiring, probing mind. There's also an important practical fact to make about the questioning, Chair, that took place. And this was in November 2025. When Mr. Mokgotsi testified then, he was legally represented. His legal representatives did not object to the questions that are now being complained of, the questioning. The complaint is only raised later, when the witness is due to return to the witness box. And I'd submit that that timing is telling.
But of course, the lack of objection is not in and of itself determinative.
That's correct. That's correct, Chair. But one would think that if the degree to which Mr. Mokgotsi is complaining now about it, that if it was that serious at the time, that there would have been a complaint at the time. There wasn't. But we have addressed the complaint nevertheless, because one ought to still address the substance of the complaint. Correct, Chair. There's one additional point which I didn't indicate in my opening, but it's about, and it came up again in the questions, it's about ignoring leads that are relevant, information that's provided, that's ignored. And what Mr. Mokgotsi says is that he provided certain leads and they were not pursued. First of all, that's not a recusal point. The Commission is assisted by evidence leaders and investigators. The evidence leaders and the investigators decide what to investigate, when to investigate it, through which witnesses, and whether something warrants investigation. A witness who provides information does not acquire a right to dictate the Commission's investigative priorities. So failure to pursue a witness's preferred leads immediately does not establish bias. There may be many reasons, but Chair, in Mr. Mokgotsi's affidavit, he does deal with this complaint, and what one sees.
I noticed that you too fall into the trap of bias. instead of substantive unfairness.
Absolutely. Well, it doesn't even establish bias, let alone substantive unfairness. So on their test, it doesn't even meet the grade. There was the Section 252 information. There was the crime intelligence procurement information, and so on, and that's addressed fully in the affidavit. In fact, the Section 252 investigation was thoroughly questioned and probed during Mr. Mokgotzi's evidence, and we've attached the entire transcript, which is why this is bulkier than it should be. It's because we've attached the transcript to show in the many different places in which that lead was tested and questioned. We are not at liberty, and nor are we required to say how else we are pursuing these leads and these investigations and the other witnesses who have come to testify here, including those who may have come in camera. And that's where I'm going to leave it. It's just not a witness's...
The test with regard to those leads would have to be how, if at all, does the fact that they have not been dealt with, how does that impact on the retention of the evidence leader, with the result that there would be substantive unfairness? That is what Mr. Mokgotzi would have to show, and I'm not aware that there has been any attempt to show that at all with regard to those leads.
Chair, there's nothing in the affidavit that suggests that it therefore is going to mean that Mr. Mokgotzi is being treated unfairly. Maybe it will be to the detriment of the Commission. It won't have a full picture if those leads are not pursued, or something at best. And again, there are many reasons for when and how evidence is placed before the Commission. Some leads require further corroboration, further witnesses, etc. All of that is entirely separate to the questioning of Mr. Mokgotzi and whether Mr. Chaskelson can continue to question him, and whether there'd be any unfairness in that.
Yeah. Yes, please continue.
The final point before I conclude, Commissioners, is that the timing of the application does matter, because the questions that are complained of go back to 2025, and then the WhatsApp complaint starts in 9 and 10 March. But the application is only brought when Mr. Mokgotzi is due to return to give evidence. And the reason I'm raising this again, this issue of the delays, for the two reasons. The first is a practical one about protecting the Commission's proceedings. And in fact, in Burnett, the case that's put up by the applicant, the only aspect of this case that's of any relevance to this application, in fact, and it doesn't help the applicants, is that paragraph 71, where the court says the following about complaints of when complaints of reasonable apprehension of bias should be made. And the court says this, the Constitutional Court: it is highly desirable, if extra costs, delay, and inconvenience are to be avoided, that complaints of this nature be raised at the earliest possible stage. So I raise it for that point. It's a practical point, and it's about protecting the Commission's resources, time, and its proceedings. The second is, what I submit with respect, is that properly understood, what it shows is that this application is just another stratagem to manufacture further objections, to secure further postponements, and to ultimately avoid testifying before the Commission. So for those two submissions, I say that the delay is relevant. So in conclusion, Chair, let me finally submit that the application should be dismissed. And we submit, with respect, that the Commission should find that there is no legal basis that's set for a recusal of an evidence leader, as if he were a judge or a decision maker, that the applicable inquiry is whether continued involvement would cause substantive unfairness, that Mr. Mokgotsi has not established any such unfairness, that the allegation that Mr. Chaskalson has induced false evidence is unsupported and is contradicted by Mr. Mokgotsi's own submissions, and in my own personal opinion is a reckless and slanderous allegation, but that's my own personal opinion. Mr. Mokgotsi placed before the Commission a materially incomplete WhatsApp record and admitted to deleting material from it. He should therefore be referred to investigation for possible perjury, forgery, and contraventions of Section 5 of the Commissions Act and Regulation 12.1 of this Commission's regulations. And thus, in short, Chair, if the Commission were to rule that this application falls to be dismissed, we would finally say that then what must appropriately follow is that the Commission directs that Mr. Mokgotsi's evidence proceeds without further delay. And of course, the appropriate evidence leader would be Mr. Chaskalson. Thank you, Chair.
Thank you, Ms. Hazim. Yes, Ms. Mohumane.
I see no it's I'm uncertain if...
Oh, your mic, please.
I apologize, Chair. Thank you. I see that it's lunchtime. I'm uncertain if Chair would...
Our preference is for you to reply, but not more than 10 minutes.
I'll confine myself to the 10 minutes, Chair.
Yes.
Thank you. Thank you, Chair. In reply, I will start firstly by talking about the deleted calls. What is shown in the MC2, which is the WhatsApp chat of Mr. Chaskalson, it's that these are missed calls. And Mr. Mokgotsi further says that he deleted them in his WhatsApp because they were missed calls and he saw no significance in having them. Now, Chair, further, Annexure MC2, which will be Mr. Chaskalson's WhatsApp, which is the WhatsApp that comes without any calls or emojis being deleted. The first page, which depicts the 9th of March 2026, it will be page 35. Chair, what I want to submit is that if the Commission looks right on top of the chat, there's a word there that says nose. And there's a time that says 8:56 a.m. Now, Chair, with that, my submission is that even Mr. Chaskalson has not brought the entire conversation between himself and Mr. Mokgotsi. With that little that appears, it's evident that there's been some discussions prior to the one of the 9th. Now, Chair, my submission with regards to that is it prompts that messages that come prior to that, which are conversations between Mr. Mokgotsi and Mr. Chaskalson, also be looked at. Because there's nowhere in the affidavits, both of the applicant and that of the first respondents, that makes reference or gives the Commission an explanation as to what was discussed prior to this date of the 9th.
But Mr. Mokgotsi is the applicant and is the one who's suggesting impropriety. If by the lack of texts or the fullness of text in this regard, you want to make some point with regard to impropriety, Is it not so that as the applicant, Mr. Mokhosi should have told us what's happening there?
It's true, Chair,
Yes,
but then
yes, yes.
it takes away this impression that has been created that Mr. Mokhosi is the one who reached out to the evidence leader, and this happened on the 9th.
But don't the calls that I referred you to earlier show that it is he who appears to have reached out? And in addition to that, I think Commissioner Baloyi took you to the detail of what actually happened, and also lack of denials by Mr. Mokhosi in his replying affidavit with regard to who actually initiated all of this. So your point cannot stand. Do you remember that engagement by Commissioner Baloyi?
Yes, I
And when
remember.
Commissioner Baloyi made specific reference to what is lacking in the replying affidavit with regard to allegations made by the chief evidence leader. So I don't see how you can make the point you are now attempting to make.
Your chairman
Can I just add to that before you answer based on your instructions? In the founding affidavit, that the whole of paragraph 6 it sets out the heading is detailed factual basis for application, and Mr. Mokhosi speaks only to the 9th and 10th. So those are the relevant facts, that what he says are the relevant facts for purposes of this application. And if you look at that WhatsApp message that you are relying to on, rather MC2, the first call is on the 9th of March, is at 8:56 p.m. Can you see that? Because this thing has got dates on it when communication started. So you've got two things. On Mr. Mkhotzi's facts that he relies on for this application, he selected the 9th and 10th to speak to. And then the WhatsApp that you've referred to, in fact, records what happens between them from the 9th. So what happened on the 8th, Mr. Mkhotzi didn't consider it to be relevant. He hasn't placed it before us.
In addition, look at 6.3. There is specific reference to 20H56, and indeed you do see the 3-minute call at 8:56. So Mr. Shaskalson's focus is there or relates to that timeline. So that's why his focus and additions of what are missing from Mr. Mokhotsi's chats focus on that timeline. So you cannot fault Mr. Shaskalson by not saying anything about the nose at the top, appearing at the top. That would be very unfair. His attention has been drawn to 8:56, and then he focuses on that timeline. Do you follow? Do you follow what I'm saying?
I do follow, Chair.
Yes, yes. Can you continue with your submissions then?
Chair, further, there was an issue that was raised by the second respondent regarding the contents of Mr. Mokhotsi's affidavit with a further postponement when Mr. Karim was giving testimony.
6.10 on page 14 and 6.20 on page 17. Because I had a question there also. What should we make of that? If Mr. Mokhotsi himself says, I gave Mr. Chaskalson this information in order to engineer a postponement of Mr. Karim's evidence, Because that is serious interference with the work of the commission. If you are giving evidence leaders misleading information and your intention is to engineer a postponement of a witness who's in the witness box and giving evidence. So as you deal with that point, can you please address that?
Will do so, Commissioner. In reply to 6.10, read together with 6.11, these are events that transpire whilst Mr. Mokgotsi is trying to get information or whatever evidence that the evidence leader can use. And now my submission on that is that he mentioned the health department tender, which is contained in paragraph 6.11. And he also mentioned Mr. Maumela and Suleiman in paragraph 10, hoping that in light of this information, he might go and get an opportunity to get more information that was required from him, from the evidence leader. That is how I understand this.
So he doesn't say that. He says, I did this deliberately to encourage him to postpone Suleiman's testimony, as I was already concerned about the Commission's treatment of me and its focus on issues outside its mandate. He does give a reason why he engineered that. He was trying to engineer postponement in favor of Mr. Karim.
Ms. Momani, look at 6.10. He says he began by suggesting that Mr. Chaskalson should ask Mr. Karim about a meeting that took place between himself, Maumela, and Suleiman. And then he says that meeting never took place. So he lied when he said there was such a meeting. And then he says, I did this deliberately to encourage him to postpone Suleiman's testimony.
And he further, Commissioner, says, as I was already concerned about the Commission's treatment of me and its focus on issues outside its mandate.
Yes, so my issue is, why would he mislead the evidence leader about a meeting that never took place, and him saying under oath that he did so in order to engineer the postponement of Mr. Karim's testimony?
The answer to that question, Commissioner, it's on the last two lines of that paragraph. He says he was concerned about the Commission's treatment and the focus on issues outside its mandate.
So I'm going to leave it at, you believe that him misleading evidence leaders to engineer a postponement of another witness is justifiable if he's concerned about his own treatment?
That is not my comment, Chair, and that is not my belief. I'm merely directing the Commissioner to say that in that same paragraph, he gives an explanation to say that he was concerned about the Commission's treatment and its focus. I'm mindful not to be found to say that his concern was correct about making mention of a meeting. I'm just merely emphasizing that he states that this is the reason he did it. It is not my opinion as to whether it is right or not.
I appreciate that. Thank you.
So we are dealing with a witness who will say or do anything based on what he wants. It doesn't matter if that may be untrue. Effectively, that is what is happening here, or not? Yes. Do you agree with me? I think you must. You must.
Chair, in response to the question, firstly, I'll respond by saying it's improper.
Do you agree with the proposition I've put to you I'm not asking about, that's not the question. The impropriety, if I am correct, is obvious, so that's not where I am. Do you agree with the proposition I put to you?
Can Chair repeat the proposition again?
I say, based on what the witness is saying here, we are dealing with a witness who will say or do anything, regardless of its truthfulness or lack of it, depending on what he wants under the circumstances. That's the sort of witness we are dealing with, based on what we read here. Do you agree? You must.
Chair, may I answer it in twofold, Chair? Yes, I agree.
Thank you.
And if Chair permits me, may I...
Can I ask my next question before
Yes,
you
Chair.
go there? You may go afterwards.
Yes, Chair.
So if that's the sort of witness we are dealing with here, what must we make of that? In the broader scheme of things. And by that I mean with regard to this application. I'm not talking about Mr. Mokgotzi's testimony with regard to the investigative process. What must we do with that, or what must we make of that in the context of this application?
Earlier during the proceedings, Chair made an example about a father and a child. And Chair said that a man of value, a staunch father, would know what he had uttered and why he didn't utter. And Chair will understand where I'm going with
I
that
don't.
example.
I
I'll
honestly
explain it so
don't.
that Chair
Okay,
understands.
Okay.
Chair, a child in a house who lives with very strict parents and he gets a good beating when he does something. Even if he hadn't done it, to avoid getting a good beating, he would simply say, yes, Dad, I did it. Now, why that example, Chair? We have Mr. Mokgotzi, who, according to his papers, believe that if he doesn't deliver, as per the agreement, consequences are going to befall him. Now, if consequences befall him, there'll be adverse consequences. He then turns into this.
I'm not sure I follow that in the context of Mr. Mokgotzi saying, I did this deliberately to encourage him to postpone Suleiman's testimony.
It's
So
to run
I don't see
It's
the
to run
relevance.
away, Chair, from the consequences. The consequences that he
So
fears.
basically you are explaining why he lied. Is that what you are saying?
Chair, in light of what is contained in the papers.
Are you explaining why he lied?
From what is in the papers, yes, Chair.
Yes. Now, that takes me back to my question, which is, so if we have a witness like that, what must we make of such a witness in the context of this application, this interlocutory application? That's my question.
Chair, that leaves the Commission with nothing other than to find on the credibility of the applicant.
Please, I think the 10 minutes is...
It has elapsed, Chair. Can I just see for a second, Chair, if there's any other thing
Yes,
I wanted to address?
All right.
Just one aspect. Oh, sorry, Chair. I apologize. Chair.
Please continue, Ms. Mohammed.
Thank you, Chair. On just one aspect, the timing of the filing of the application. Chair, it's common cause that Mr. Mokhotsi did not have attorneys from, I think, January of 2026. And according to the letters that were filed in the commission, my attorney only came on record, I believe it was during the Easter holidays. I do not recall the exact date. Now, from the time he came in to consulting and raising these issues, it still falls within a reasonable time.
On my reading, I don't remember reading that explanation in the affidavit. Is it there in the reply?
No, it's not. It's not in the replying affidavit. It's merely.
Should it not have been there? You know what judges will usually throw at counsel, which is, counsel, I am now testifying from the bar.
I'll retract that submission. I have nothing further to say, Chair.
Thank you very much, Ms. Mohomane. Let's adjourn and resume at 2:30.
Hello, my sister. Don't let.
Good afternoon, all. It's 29 minutes past 2. We are about to resume. Please make sure that your cell phones, all devices are muted. Thanks very much.
Good afternoon, Ms. Hassan. Good afternoon, Ms. Mohammed.
Good afternoon.
The application is dismissed. Reasons will be given during the course of next week, if not the week after. The effect of the dismissal of the application is that Mr. Mokhodzi's evidence will be heard today, but we will have to take an adjournment. I will not indicate after how long we'll come back, but we'll come back not long from now for the hearing of the evidence. And Mr. Mokhodzi will be led by the Chief Evidence Leader, Mr. Shaskalsin. That's the effect of the dismissal of the application. Let's adjourn. Oh, sorry. Yes.
Thank you, Chair. Chair, I have been instructed to place on record that in light of the outcome of the recusal application, Mr. Mokhodzi wishes to bring a review application. We thought it prudent to bring it to the attention of the Commission.
But because there's no interdict at this stage, we will be continuing with the hearing of the evidence. Let's adjourn.
We'll start in 1 minute. All right, we are ready to resume the hearing. Please, again, make sure that your devices are muted, off. Keep them quiet, please. Thank you.
Good afternoon, Mr. Mokhodzi.
Good afternoon, Chair.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thanks, Chair. Good afternoon, Mr. Mokhodzi. Good to see you again.
Chair, may I say something, please?
Yes.
Thank you, sir. Thank you very much, Chair.
Yes.
I think it's very much important that I put this into record regarding the whole process as how it unfolded. It should be recorded again, Chair. I have noticed the proceedings, including when my counsel speaks, she got interrupted more than 10 times. The counsel here was allowed to speak. When my counsel tried to read one case law into record, it was that, no, we know it. The other counsel had an opportunity to speak uninterrupted for so long. Secondly, Chair, when I came here before, I came voluntarily, and as it was also put in my affidavit, the information that I said will need to be corroborated and be converted into evidence that is required or needed here. I've given that all. I was declared a liar. I kept on saying I had to do the affidavit so that we could process the 252A. I was declared a liar again. And now today, again, I've made an application for the recusal of the chief evidence leader, which it was fair, it was done properly. It is within the discretion of the commission to arrive at a certain conclusion. By so saying, Chair, I want to say I'm very much unhappy with the proceedings. Thank you.
Thank you, Mr. Mokgotsi. I've heard you. We will continue with the hearing of your testimony. Thank you.
Mr. Mokgotsi, since you last testified, both General Sabia and the person you say was your co-handler have testified. And I just want to clarify certain discrepancies between what you told us and what they told us. General Sabia said two things that are at odds with your evidence. The first was that he said that he hadn't met you before the January 8th event in Cape Town, that was the first time he met you. And the second is that at no stage when he met you did he ever discuss any official policing business or operational, investigative, or intelligence matters. So I just want your response to each of those.
Yeah,
was General Sabia correct to say that the first time he met you was at the 8th January event?
Yeah, to all the answers, I'm not going to incriminate myself. Going forward, Chair.
But I don't understand how you can incriminate yourself in relation to whether you met General Sabia before January the 8th or only on January.
As I said, I'm not going to incriminate myself.
Please explain how that incriminates you.
By answering that question, Chair, I'll be incriminating myself again. I therefore request to rather invoke my right to remain silent.
How does this incriminate you, Mr. Mokgotsi?
That's the answer. I do not want to incriminate myself any further. That's the answer, Chair.
Doesn't answer my question. I hear you when you say you do not want to incriminate yourself. What I want to understand is how this incriminates you.
I don't want to incriminate myself, Chair.
It is open to a witness to adopt that stance. But it does not mean that that necessarily makes sense in all instances. I should just draw it to your attention that the section, I think it's section 6 of the Commissions Act, and there's also, is it Regulation 8(1), if I'm not mistaken. But there's also provision in the regulations. Both create an offense if a witness that has been sworn in fails to answer fully and satisfactorily any question lawfully put to them. So for you to simply say this incriminates you, you don't explain how, you don't explain what the crime is, we are completely in the dark. It may well be that we may have to consider this. I am not saying that you are not entitled to raise what you are raising. It may well be that there is a basis for substantiating it and for exculpating yourself from the possible applicability of Section 6 and the relevant regulation. But I think it only fair that I should draw your attention to the provisions of these statutory prescripts. So are you still insisting that that's the
That's my
attitude you are
posture, Chair.
adopting?
That's my posture. I've gone through those rules, and as a layman, I may not have full comprehension as to how they work. Perhaps my legal team will talk to that, but I'm not going to incriminate myself.
Yes, Mr. Shaswasi?
Chair, I think it is possibly appropriate for Mr. Mokgotsi to take some legal advice on this, because certainly the attitude of the evidence leaders is that, subject to any plausible reason for a fear of self-incrimination, the evidence leaders would want a refusal to answer questions to be followed by a referral for prosecution under the relevant provisions of the Act. And while I can understand that there are certain questions that I want to ask today that might legitimately elicit an assertion of privilege against self-incrimination, I certainly hadn't imagined that this one would. And there are going to be a lot of questions that are going to give rise to this issue. So I think Mr. Mokgotsi needs to understand what his legal position is, and I don't want him to be put into a position where he ends up being prosecuted for refusing to answer questions, believing that he has a right to do so when he doesn't.
No, Chair, I'm not refusing to answer questions.
Mr. Mokgotsi, I will invite you and I want to hear you.
All right.
Ms. Mohumane,
Chair.
do you want to take the opportunity to talk to your client? Perhaps let's just adjourn. Let's adjourn. We'll come back when it's indicated to us when to come back.
All rise. We are ready to resume. Please switch off your cell phones. Thank you.
Yes, Ms. Mahumane.
Thank you, Chair. Chair, I have obtained further instructions together with my attorney from client regarding the situation. Chair, my instructions are that prior to the instructions, we've also looked at the provisions of Regulation 8 and Regulation 12 of the Rules of the Commission, and we've extensively advised client on same and the repercussions that fall forthwith. Chair, my instructions are that Mr. Mokhotsi has voluntarily made himself available to the Commission, and he gave evidence without being summoned to come. It is not a refusal to answer questions specifically with regards to General Sibia. His response thereto is that he will not incriminate himself any further, thus will not answer the question. If the Commission so requires, it may also ensure, or rather just double check with Mr. Mokhotsi if whether those are the correct instructions.
I'm not sure whether I follow. Is the stance that Mr. Mokhotsi this afternoon will not be answering any questions, and that his stance with regard to all questions put to him is that he will not answer, and that he will claim his privilege against self-incrimination in response to all questions?
Chair, thus far my instructions fall on the evidence of General Sibia. I'm uncertain.
That's what confuses me. I'm not sure I follow that.
Chair, if I may, I see a nod from Mr. Mokhotsi when Chair asks that would it be with all the other witnesses, and I see a nod from Mr. Mokhotsi's side. May Chair confirm for me?
Yes. Perhaps let me ask you directly, Mr. Mokhotsi. I'm not sure that I follow your counsel. I want to establish from you whether your stance is that you will claim privilege against self-incrimination in response to all questions, whatever their nature.
Chair, I'll sit here and wait for all the questions. I will respond to each and every question, as I said. If question is posed, I'm not refusing. If I say I do not want to incriminate myself, I'm answering. I'm aware of the repercussion, as I'll be in contempt with the Commission. So I'm saying a self-incriminatory kind of environment, I believe I should be given an opportunity to do that. I'll wait for every question, I'll respond. I won't say I put a blind blanket in all the questions. As they come, I will respond.
Mr. Shaskelson, I guess the best way to deal with it is for you to put all your questions to Mr. Mokhotsi.
Let's proceed then, Chair.
Yes,
yes. My first question was, is General Sibia correct to say that the first time that he met you was in Cape Town around the January the 8th event?
I'm not going to incriminate myself, Chair.
And my second question is General Sibia correct when he told us that he never discussed any official policing business or operational, investigative, or intelligence matters with you at any time?
Still, I'm not going to incriminate myself, Chair.
Then let me proceed to another question. The man who you have described as your co-handler has said that he met with you and General Sabia in Bryanston well before January the 8th, 2025. Is that correct?
Not going to incriminate myself, Chair.
Let's proceed. When you were at Parliament, you withdrew your allegations against General Mkhwanazi and King Misisulu, and you apologized for casting aspersions on them. Can we then accept that from your perspective, the Commission doesn't have to pursue those allegations further?
Like I said, every question I will respond, Chair. Indeed, in Parliament I said so, but I do not want to incriminate myself, Chair.
Let's move on to your status as an agent or an informant. Can I ask you to go to page 8 of the exhibit bundle?
Chaskalson, Chair made a ruling the other day that we should refer to CJC numbers for the transcription. CJC is 40.
CJC 40. I can see myself running into difficulties on that. Can you get me? Can you just email me an index so that I can?
Chaskalson will assist you because we have the physical file. So if you give us a page number, we'll refer.
Thank you. So on page 8, there is an affidavit from a colonel in the Division of Crime Intelligence who is the section head of undercover operations and agent program. And you'll see in paragraph 1 that colonel states, this section is responsible for registration of all undercover operations and deployment of undercover agents, either discharged or non-discharged agents for head office in 9 provinces. And then he says, Mr. Brown Mkhotsi with identity number, and he gives you identity number, has never been in our program as an undercover agent. There are no records that indicate that Mr. Mkhotsi was ever an agent. In our manual database and a computer system, his name does not appear as a person that was ever an undercover agent. As the Undercover Operations and Agent Support section, we provide operational support functions and administer all agent files for members of the South African Police Service. The management and administration of all undercover agents, regardless of the division, component, or province where a person is placed, is the responsibility of this office. Undercover agents are members of the South African Police Service. Mr. Brown Mkhotsi was never employed, enlisted in the South African Police Service. His name does not reflect on the record systems of the South African Police Service. I therefore deny that Mr. Brown Mkhotsi was ever an undercover agent of the South African Police Service. So the person charged with maintaining all of the records of undercover agents in the South African Police Service Criminal Intelligence Division denies that you were ever an undercover agent. Do you have a response to that?
I responded in Parliament. This person only got appointed in 2024. I know how he got appointed. I know where he used to work. He can never know me. Therefore, I would not want to implicate myself.
Sorry, are you asserting a privilege against self-incrimination not to answer that question?
Yes, that's correct. That's the answer I'm going to give to all the questions, by the way.
Well, we'll still go through the questions one by one.
Yes.
Who informed you that you were acting as an agent?
I'm not incriminating myself, Chair.
Did anybody inform you that you were acting as an agent?
I would not want to incriminate myself, Chair.
Let's go down to the next annexure. I think it would be CJC 41. It's at page 10. And there you'll see this is an affidavit with a colonel stationed at the Secret Services account in the Division of Crime Intelligence. And the colonel says, I am the acting section head of finance responsible overall management of the financial administration of the Secret Services account. Part of my duties include administrative management of informer database nationally. The SSA Central Informant Index falls under the control of the Divisional Commission of Crime Intelligence or his/her delegate appointed for this purpose and serves as the nodal point for the registration and handling of record checks relating to informants. All active and inactive informants are placed on the register, as it is important to know if a person is or has been an informant previously. Paragraph 4. A record of all known information peddlers, hawkers is kept on a separate database to ensure that such persons' particulars are supplied for record purposes. The bona fides of such persons must be placed under suspicion as they're normally not trustworthy and attempt to provide information to the highest bidder, irrespective of the consequences. And then if you go down to paragraph 5 on page 11, the Division of Crime Intelligence is responsible for registering and managing informants. All registered informants are subject to verification every 6 months. During this process, handlers and their immediate commanders are required to physically verify the source and submit a certificate to this office for capturing. The ID number, and your numbers given, belonging to Mr. Brown Mokgotsi was tested against the Crime Intelligence database. This ID number is registered in the CAPFIN system with the, and it's been redacted. The source was handled by and it's redacted, and co-handled by and it's also redacted. The source was registered on 9 January 2001 at Soweto cluster, and the same source was deregistered on 20 August 2001. The handlers requested an amount of 1,200 rands for recruitment fee to motivate the contact. According to our report, there are no other financial transactions relating to the source for the period he was active in our system. So the colonel responsible for administering crime intelligence records of all informants says you were an informant for a brief period in 2001, but there is no record of you being an informant ever after. Do you have a comment on that?
No incriminating, sir.
Sorry?
I don't want to incriminate myself.
Now, in fairness to you, I should place on record that the person who you describe as your co-handler says that he was aware that you were being run as an informant. He does confirm that you were being run as an informant. He, however, was emphatic that you were never an agent, only an informant. Do you want to comment on that?
I don't want to incriminate myself.
In your affidavit, you described yourself as a contact agent. The person who you referred to as your co-handler says there is no such thing as a contact agent. Do you want to comment on that?
I'm not going to incriminate myself.
And that person also testified that you and he were homeboys from Soweto and knew each other outside SAP's work. What is your response to that?
I don't want to incriminate myself.
Now, in your statement, you say that your handler was Warrant Officer Mabizela. Do you stand by that statement? There are 6 different references in your statement to Warrant Officer Mabizela as your handler.
Yes, Mabizela, Mabuza. I understand that. I don't want to incriminate myself.
Sorry, you said Mabizela Mabuza.
I don't want to incriminate myself.
You don't want to incriminate yourself. Well, the man who you describe as your co-handler was adamant that you were never handled by Warrant Officer Mabizela, only by Warrant Officer Mabuza. What's your response to that?
Let me not incriminate myself, Chair.
And the man who you describe as your co-handler was also adamant that he wasn't your co-handler. He said he just played a supervisory role in relation to Warrant Officer, a minor supervisory role in relation to Warrant Officer Mabuza. Do you want to respond to that?
I don't want to incriminate myself.
He said the primary supervisory role in relation to Warrant Officer Mabuza was played by a Colonel Duma who was later promoted to Brigadier Duma. Do you want to respond to that?
I don't want to incriminate myself.
And he also said that Colonel Duma was involved as the supervisor of your handler, Warrant Officer Mabuza, right from your first alleged meeting with the man you describe as your co-handler. Do you have a response to that?
I'm not going to incriminate myself.
Can you explain why there is no mention of Colonel Duma in your statement?
I'm not going to implicate myself. He was Brigadier Duma, actually. Let me not incriminate myself.
Well, he was later promoted to Brigadier Duma, but at the beginning we are told he was Colonel Duma. Can you say why there's no mention of him in your statement?
Let me not incriminate myself.
Can you say why there's no mention of Warrant Officer Mabuza in your statement?
Mabuza and Mabizela is almost the same name. They refer to one person, but let me not implicate myself.
So if I understand you to say that Mabuza and Mabizela are the same person.
Let me not incriminate myself, Chair.
A person who was your co-handler said he introduced you with Colonel Duma, Warrant Officer, and Warrant Officer Mabuza to General Sabia. Do you have a comment on that?
I'm not going to incriminate myself.
Now, Warrant Officer Mabuza is dead. Are you aware, or do you want to, can you confirm that?
It's true. May his soul rest in peace.
Brigadier Duma, who used to be Colonel Duma, is also dead. Can you confirm that?
May his soul rest in peace. No, it's true, he has passed on.
General Mfazi, who you say in your statement is the first person to whom your handlers reported, has also passed away.
All of them, but let me not incriminate myself.
Mr. Mkhotsi, just so that I understand your answer, when you say all of them, I don't want to incriminate myself, are you saying all of them have passed on?
That's correct.
Or is that what you're saying? All right, thank you.
Chair, you know, when I was here, I told the commission how a man was killed. The evidence leader does not want to ask me things that I presented. How a man bought a property for 100 million, put it in his daughter's name. Those questions are not asked. Thank you, Chair.
Yes, Mr. Chairperson.
You see, Mr. Mkhotsi, there are only 2 people who may have had anything to do with your operations in crime intelligence and who are still alive. The one is the person you describe as your co-handler, and the other is General Sabia. Is there anybody else in crime intelligence who may have had something to do with your operations who is still alive?
I'm not going to incriminate myself, Chair.
Well, the two people who you have identified as being involved in your alleged role as a crime intelligence operative are first General Sabia, and he denies ever discussing any police matters with you. Can you comment on that?
I don't comment, I don't want to implicate myself.
And then your co-handler testified to us that he had very little to do with your operational activities. That was all handled by Warrant Officer Mabuza and Brigadier Duma. And he can't account for any, he has no knowledge of any reports that you gave to Warrant Officer Mabuza or Brigadier Duma. That was his evidence. Do you want to comment on that?
No comment.
You see, Mr. Mokgotsi, I'm genuinely wanting to point something out here which may be to your assistance. It's not just Mr. Karim who is throwing you under the bus. It's everyone in SAPS who has ever dealt with you who's also throwing you under the bus. And you need to think about that in relation to your answers.
Yeah, but I never fell under the bus.
Sorry? You never yes.
Let me not incriminate myself, Chair.
Let's look at your alleged crime intelligence investigation. What were you told to investigate in relation to crime intelligence?
I'm not going to implicate myself, Chair.
Sorry, you're not going to?
To incriminate myself.
I see. Who was the target of your investigation into crime intelligence?
I'm not going to incriminate myself, Chair.
Mr. Mokgotsi, you've criticized me for not following up your alleged leads in relation to crime intelligence properties. Who tasked you to follow those leads?
Let me not incriminate myself. You know, Chair, the gentleman who seated here, he came to the lawyers with a document saying, Mr. Chattel say you must check this to be presented here. Before you made a ruling, Senior Chattelson knew he was going to come and ask me a question because he sent this gentleman to come and see my lawyers and say, you say you must prepare yourself. Let me not incriminate myself, Chair.
Yes, Mr. Mokgotsi, to set the record straight, between Advocate Hasim and ourselves, we agreed that we would both prepare to ask questions to you and that I would take responsibility for preparing if there were any additional documents that had to be put before you. That is the context in which that document was presented to your lawyers. If the recusal application had gone your way, Advocate Hasim would be here asking the same questions as I'm asking.
Thank you, Chair.
You understand the point?
Yes, very well. Thank you, Chair.
So your testimony would have been heard regardless of the outcome. If the application had been granted, Ms. Hasim would have been the one questioning you now. So those documents would have been relevant.
Either way.
Either way, yes.
Thank you, Chair.
Yes.
Mr. Mokgotsi, what did you discover in your investigations into crime intelligence?
I'm not going to incriminate myself, Chair.
Why did you criticize me for not pursuing leads that you allegedly offered me in relation to crime intelligence properties if you weren't prepared to testify to that for fear of self-incrimination?
Chair, when I came here with evidence, in everything I said, this is two questions you asked me. My ID number and the matter in the Northwest Health Department. Very relevant. The narrative was to prove that I'm a liar. Everyone, they know I'm a liar. None of the things that I submitted or anything that I wanted to have been corroborated were never entertained till today. Let me not incriminate myself, Chair.
Did you report your discoveries to General Sabia?
I'm not going to incriminate myself or General Sabia.
Did you report your discoveries to General Khan?
I don't know General Khan. I never worked with General Khan, and I'm not going to incriminate myself.
The man you describe as your co-handler says that he works with General Khan and regards General Khan as his close friend. Are you aware of that?
That is something that I should not incriminate myself with.
Let's look at the documents that you wanted me to investigate. Can I ask you to go to page 64 of the evidence bundle, sorry, of the exhibit, of the annexure bundle. It's annexure BM 7.23. Six four. BM 7.23. Do you have the document?
I do, thank you.
And if I understand it correctly, it is an image of a route from one property which I understand you to say is a property that was irregularly purchased by crime intelligence to a new property where the business on the old property now operates. Is that correct?
I'm not going to incriminate myself, Chair.
I see. Where did you get this image that you sent to Mr. Madlanga on the 2nd of January at 11:57 in the morning?
I'm not going to incriminate myself, Chair.
Let me ask a follow-up question. Why did you send this to Mr. Madlanga?
I'm not going to incriminate myself.
Thank you.
Let's go to page 65. Same, the next page. I'm just going to go page by page here. And you see there at 11:57:04, there is a photograph of a brick wall and a house behind it that you also sent to Mr. Madlanga. Is this a picture of the property that we previously discussed?
I'm not going to incriminate myself.
Why did you send this picture to Mr. Madlanga?
I'm not going to incriminate myself, Chair.
And from whom did you acquire this picture?
I was going to say a source, but because I don't want to incriminate myself, Chair.
You say you were going to say a source. Can you give us details of the source? I don't want you to say out loud because I don't want to expose the identity of the source, but I would like to get the name of the source so that we can follow it further.
Even if I was prepared to incriminate myself, all the names I've given you, even one man is in hospital, is being departmentally charged. Every person I mentioned here, in camera between me and you, they've been called. But the informant, I know, I still repeat, the investigating officer of the informant, the co-handler, and the handler of the informant who was killed, I know them. Chair, evidence leader doesn't want those names of the people who are still in subs who can corroborate. Let me not incriminate myself, Chair.
Sorry, the investigating officer, the informant, you've never given us that information.
You never asked for them.
No, but I understood your first answer to be every name that you have given to us has left somebody dead. So you will admit that you have never given us the name of the investigating officer of the informant.
It's what I'm saying, Chair, that there was no interest from the side of the evidence to say, but you say this man was killed like this. Who's the co-handler? Who was the handler? Because they're there from this brigadier, the colonel, and the IO. I know them. We never asked them.
Mr. Mokgotsi, your version in relation to the man who was killed, who you described as Warrant Officer Mabizela, and who we did investigate. Warrant Officer Mabizela was not killed. Warrant Officer Mabizela was imprisoned.
Mabuza.
You didn't call him Mabuza, you called him Mabizela. Warrant Officer Mabizela is alive and well and in prison. The only Warrant Officer Mabizela in crime intelligence, who has been in crime intelligence over this period. You didn't give us the name of Warrant Officer Mabuza, so we couldn't investigate Warrant Officer Mabuza. You told us of your co-handler and you gave us his name. We have spoken to your co-handler. Your co-handler has testified in camera here. You have given us no other names.
Chair, I gave you another name. I gave you Major General Lushaba. I said he took a woman to the house. A case was opened. He got arrested for that matter. He was never called here. He's the CFO of the crime intelligence. He was never called here.
You're giving... let me correct myself. You have given us the name of Major General Lushaba as a target, not as someone to go to investigate, to support your allegations.
Okay, let me not incriminate myself.
Let's go to page 65. At the bottom of the page, going over to 66, there is a salary record of part of a SAP's salary record. Where did you get this screen with a salary inquiry on it?
I remember very well. Let me not incriminate myself.
Why did you send it to Mr. Matlala?
I'm not going to incriminate myself, Chair.
Let's go to the next page, 66. There at 11:57:05, you sent to Mr. Matlala company details of what you allege to be the company in which the crime intelligence property is housed. How did you acquire these details?
I'll just request the addresses of this property not to be displayed.
Sorry, the addresses of this property?
I was just saying I hope they are not there. But let me not incriminate myself on this. And the name of the person who the property was transferred to is also here.
Yes, you have an unredacted bundle, so you know what we're talking about. The public and the screen behind you only has redacted bundles.
Thank you.
If you were worried about disclosing this information, why did you send it to Mr. Matlala?
I'm not going to incriminate myself.
Let's go to the foot of the page. There? At the 17:57:05 WhatsApp, you send what looks like a screenshot of a business saying where they've moved from, or where they've moved to.
That's correct.
That was the business that used to reside at the property that you say was purchased by crime intelligence. Is that not right?
I'm not going to incriminate myself, Chair.
Where did you get that screenshot?
You know, Chair, I so wish during that adjournment, SC could have asked that question. I can give you the name of the person to come here who got the receipts, proof of payments of all these illegal purchases. I have.
Why don't you write it down on a piece of paper and...
It was exactly, remember I wrote the name here. Even the chair had to give an order because it went out. But it should be done differently if ever I'm prepared to incriminate myself next time.
Well, I'm inviting you to write down the name of the source of each one of these documents that you WhatsApp to Mr. Matlala.
No, Chair,
If the insinuation is that something given privately to us was leaked by us, there is no truth to that at all. We keep the documents to ourselves, and for the record, we have never leaked a single one of those documents.
Okay, Chair.
The only name that I understand you to have given to us in confidence was the name of your alleged co-handler. And
Yeah,
that
but
name has been...
it was not shown by the Commission. It just leaked to the media here. The chair also gave an order that it should not be published. I appreciate that. But I'm saying, through the lawyer, I can give you the name of person who have receipts, proof of payments, who, like your government procurement, who authorized, who signed, who approved. He has those things, but maybe that's what should be asked so that we can give to you. All these ones is just to incriminate myself.
You see, Mr. Mokgotsi, I would urge you to give us this information because what we're dealing with is something very, very important and central to this entire commission. All of these documents that we're talking about now are documents relating to the two criminal cases against General Khumalo and his co-accused. You're aware of that?
It's not yet charged for that. It's only charged for appointment of a BMW woman. It's not charged for this. And even when General Khumalo or Masemola were here, they would never be subjected to this harsh questioning like you do on General Sibiya or others.
Well, let me continue. It was the arrest of General Khumalo in relation to these charges that really triggered General Mkhonazi's press conference in July last year. And General Mkhonazi clearly regarded those arrests as evidence of organized crime, or states that he regards those arrests as evidence of organized crimes hold over the criminal justice system. So one of two things is going on. Either there is a genuine investigation into the illegal use of crime intelligence funds in relation to these properties and the illegal appointment of a crime intelligence brigadier, in which case we need as much information as possible to show that when General Mkhonazi characterized those acts as a conspiracy involving organized crime, he was wrong. That's the one option.
Chair.
The other option is that General Mkhonazi was right, and this was an attempt by organized crime to essentially frame General Khumalo in relation to false offenses. If that's the scenario, then we also need to investigate it. Either way, we need to investigate it. So I would urge you to give us this information.
That's the first thing, Chair. When I met you for the first time, I told you about that. The arrest of General Khumalo and the other generals, there's nothing to do with the properties. They were arrested for the appointment of a brigadier. For General Mkhonazi, as you say, it triggered and so forth. It's what I told you, it's what I had in mind. It's what I even said. He came to the police college here to write the statement, the July 6th, how it was staged. I presented that to you. So let me not incriminate myself further.
So you're declining to give us the information that we say is at the center of the inquiry of this commission.
I'm not declining. I'm saying it for now to come here in public and mention those things doesn't help. I could rather give that to the lawyers and the person who have the papers, proof of payments, who can prove. He wants to come here. He's not getting an opportunity. I can get that for you. But General Kumalo was not arrested for these properties. The same thing they saw about General Mkonazi and the Big Five. In the first place, how did South African Police Service appoint a Big Five Madlanga? How did they screen him? And now it's a Big Five. Let me not incriminate myself, Jay.
Can I ask you to look at the foot of page 65?
Yes.
Is that salary record not directly relevant to the arrest of General Kumalo?
Let me not incriminate myself, Jay.
I see. What about page 73? Another salary record. Next to 115710, that the second screenshot on the page. Is that relevant to the arrest of General Kumalo?
Let me not incriminate myself, Jay.
Let's go down to page 75. The screenshot from somebody whose name appears on a WhatsApp to you, dealing with the appointment of someone as a brigadier. Is that relevant to the arrest of General Kumalo?
That's relevant.
Sorry?
It is relevant.
It is relevant.
Yeah.
And are you willing to give us the details of the person whose name is there?
I mean, the matter is sub judice now. It's before the court. They even went to court today for the same matter. Perhaps it's one of the things which should be handled there.
I'm asking for the details of the name, the full name and phone number of the person whose name we see on that message that you sent to Mr. Matlala on the 2nd of January.
Let me not incriminate myself.
Are you saying it would incriminate you to provide those details?
I may be incriminated. He may be called there. He can apply for my cross-examination, and I'll be incriminated, definitely. They'll bring me, probably.
Sorry, being cross-examined is not the same as being incriminated, Mr. Mokgotsi.
Yeah, there's a layman thinking. I don't want to be incriminated, if possible, Jay.
So are you suggesting that if we speak to that person whose name we see on top of that screenshot, he may tell us information that will lead to you being criminally convicted?
I'm not sure. Let me not incriminate myself, Jay.
What about the...
Sorry, Mr. Chaskasan, can I just understand? Mr. Mkhosi, you do understand, and is that your intention, that when you speak about self-incrimination, you're speaking about self-incrimination against prosecution, criminal prosecution. Is that how you're using this?
I'm not conversant with those processes. I just learned and being advised by lawyers that I should not incriminate myself.
The reason I'm asking is because just one answer back, you said you don't want to say something and this person comes here and cross-examines you. So that's why I'm asking when you speak about self-incrimination, are you are you using it, or do you understand what it is that you're saying? Are you saying, I don't want to answer because I don't want to be prosecuted? Or are you saying, I don't want to answer because I don't want to be cross-examined? Just want to understand.
No, thank you. I understand now.
Which one is it of the two?
I don't want to be prosecuted, but this one I don't know. I know nothing, and I don't.
Okay,
want
so you don't want to be prosecuted when you say I don't self-incriminate.
No.
Okay.
Sorry, which one did you say you know nothing about?
Like the name that you said, there's so many names like this. I don't know, and I'll end up incriminating myself with this name.
Mr. Mokgotsi,
Unless
you're
you
edging
refer-
towards perjury here.
Unless
I
you're
find it
referring
impossible to believe that you are unable to identify the name of someone in your phone book who has a name on a WhatsApp that is sent addressed to you.
Yeah, to avoid perjury, let me not incriminate myself.
No, you can't plead a privilege against self-incrimination because you might perjure yourself if you give a false answer. The privilege against self-incrimination applies only to true answers.
That's correct. But remember I said, Chair, why am I not giving opportunity? If any of these things would have to be given to you, should come through the lawyers. That I don't come back here and incriminate myself.
I don't follow what you say about something coming from your lawyers. What exactly are you saying?
Chair, I'm saying if there's anything which probably the evidence leader may want, because as he lead evidence, remember he's asking me about things that, the information from my phone, that can't it be useful that I perhaps give through the lawyers whatever he wants if I have? Because others, you may find I'm not clued up with it.
Yes, Mr. Chairperson.
Now, I'm going to repeat my question. Can you give us the name and contact details, the full name and contact details of the person whose name appears at the top of that WhatsApp? Whose first name appears?
Yeah, I only knew this person as this is written, and remember my phones were taken by the police, so I'm not having those old numbers anymore. But I only knew him like this, so that's the answer.
So you're telling us you just don't know the answer to that? You are unable to give us
Not that I'm
the answer.
able.
Is that what you're saying?
No, Chair. This name I know it is. So you want the name and the surname, which I don't have the surname. You want the contact numbers of this person. They are gone with the cell phone.
So you don't know how to get hold of this person?
I'm not sure. I cannot. And now no one trusts me. Remember, I'm a liar now.
Where does this person work?
Let me not incriminate myself.
Mr. Mokgotsi, maybe just also to make the observation that there is a difference between refusing to answer a question and because you don't want to answer the question, and there's also the I won't answer the question because I will incriminate myself if I give you the answer. So when you are asked a question about where is this person employed, and your answer, and you don't want to give that answer, it's not self-incrimination. It's you're refusing to answer the question.
Yes, I understand.
Is that you understand the
Yes,
difference?
I get your point.
Okay, thank you.
Well, let me try again. And let's call this person John.
John.
Okay, John. Okay, we'll just call him John. His name is not John. We know what his name is. The screenshot reflects that at 11:27 you asked John, and then somebody's name is included there, by julle aangestel as 'n brig. So you asked whether that person who we know was appointed as a brigadier at Crime Intelligence is by julle aangestel as a brig. So can we infer from that that John works in Crime Intelligence?
Yeah, you see, this message, I think it was forwarded to me because the language written here, there's no way he and me can speak in this language. So this John, I don't know, I can't find, I only knew it's John. I can't find this John.
Now, a short while ago, you were saying to me that you couldn't identify John because John may have been on your phone, but your phone has disappeared. So,
No, PK, they took it, the PK.
sorry?
It was taken by the police.
Yes, taken by the police.
It means we can
So
go
you
to
don't
my
you don't
phone.
have your phone anymore, so you can't tell me who John is.
No.
Now you're saying something completely different. Now you're saying, no, John didn't send a WhatsApp to me. John sends a WhatsApp to somebody else who forwarded it to me.
No, Chair, I'm saying the language that is written here, you may find it was forwarded, this portion. And now this John, I only knew this John on my phone like this. I don't have his surname and I don't have his numbers.
You've never had his number?
Of John.
Of John, yes.
No, John like it was in my phone. I don't know his surname. So
Yes.
if you say I should go and look for him, I can't find him.
Yes, because you don't have your phone anymore.
Yeah.
But
if I
what you
can
asked John,
But Chair, if I can be, what I've just requested, in assisting this process, if there's anything which perhaps senior counsel may want to be, if it can be done with my lawyers, all the names, whatever that he needs, like things that I said, I did talk about the names. I'm ready. I can get the lawyers to even that they can submit them to senior counsel. Not only John, anything that is here, perhaps the names and the surname, like you say, you want to go and do some investigations. It can help, Jay.
Mr. Chairperson?
I would like to know John's name and number.
Chair, I'm going to object. I'm going to object, Chair. This,
Just before that. Yes, Ms. Mohammed.
thank you, Chair. The question that the evidence leader is putting to Mr. Mokgotsi, I believe has been asked on numerous occasions, and his response thereto is that the phone is not available. It was taken by the police. He doesn't know how to get a hold of this John. Now, asking him on numerous occasions, he's already given the answer. That's the basis of my objection, Chair.
Thank you, Ms. Mohammed. Yes.
I may have misunderstood Mr. Mokgotsi, but I thought he was inviting me to ask through his attorneys for names and numbers. And the one name and number that I want to get hold of is John's name and number. If Mr. Mokgotsi wasn't inviting that, then I'll withdraw the request to the attorneys. But I understood him to be inviting me to ask that.
And Chair, I would understand that to be in due course upon that information, whatever information that he may have, or the names, that same will be made by the legal team for the evidence leader to have. At this juncture, he doesn't know who John is. He doesn't have his phone. It doesn't take the issue of John any further.
I wasn't asking for the answer now. I was asking for it in due course in response to that invitation.
What's your attitude to the invitation by Mr. Mokgotsi, Ms. Mohammed?
Chair, if those are the instructions, I'm certain that same can be arranged. We've had, even prior to the proceedings, where we've had meetings with the investigators together with the evidence leader. I don't see why we cannot do that when we are done here for the day. I do not have any objection there too.
Thank you, thank you. Mr. Shaskovsky?
Thank you, Chair. Can I just clarify that you were the one who wrote, or are you the one who asked the question, and then the name is there, by julle aangestel as 'n briek? Is that a text that you sent?
I can't remember, Chair.
Well, let's go later down. If we go over the page, we see how the conversation proceeded. It said, nou, hoe het sy nog steeds nie 'n personal number nie? Ook enige idee of sy familie is? Did you write those?
Since this lang is not me.
Sorry?
It cannot be me. I can't write this language.
You don't write in Afrikaans?
I can't. I don't text in Afrikaans. I'm not good in Afrikaans.
And why would you send that to Mr. Madlanga on the 2nd of January?
Let me not incriminate myself, Chair.
Then the next screenshot is, again, the personal number, well, a salary screen without a personal number, no records for combination. Does that relate to the prosecution of General Khumalo?
Let me not incriminate myself, Chair.
Now, let's get to what happened after you sent all of these screenshots to Mr. Madlanga. He writes back on page 77, what is this things you've just sent to me, brother? I see it shows several registration numbers of cars and residential addresses, and you say they used state money to buy those properties. So why were you sharing this information with Mr. Madlanga?
I'm not going to incriminate myself, Chair.
Well, let me ask another question. Did either your handler or your co-handler know that you were sharing this information with Mr. Madlanga?
It will depend, but let me not incriminate myself, Chair.
Well, what would it depend on?
You see, when you work with a handler, there is a time where you submit like your report. In your report, you'll outline, this is what is happening, this is where we are, every step. So possibilities, it's just that you can't show him all these messages. If there are 100, you can say, I'm talking to Madlanga, we're working on this and this, full stop.
But would you provide a brief description of, I've shared with him a whole range of properties illegally bought by crime intelligence and details of someone illegally appointed by crime intelligence. Would you?
No, let me not incriminate myself.
Mr. Shaskovsky, is there a way of short-circuiting this?
Chair, I do think it's important that we go through it, if only to show that we are, I mean, even if we're not getting much out of the witness, I think we do need to try.
All right. How much longer do you think? Your microphone,
Yeah, no, I know. I switched the mic off because I was looking to see
sorry.
how much longer.
Okay.
I think at least an hour, unfortunately. We can.
Okay.
Let me put to you what your alleged co-handler said to us. He said that he was not aware that you were investigating Mr. Madlanga. Do you have a response to that?
As you said, Brigadier Duma, who was senior to this core handler, is the one who knew what I was doing. Even the notice for investigation went to Duma.
Why didn't you mention Duma at all in your statement?
Let me not incriminate myself, Chief.
You see, your alleged co-handler didn't just say he was unaware that you were investigating Mr. Madlanga. What he said is that if you were investigating Mr. Madlanga, sharing documents relating to your investigation of crime intelligence with Mr. Madlanga, who was a completely different target, would be bad intelligence practice. What's your response to that?
That is thinking, and there's nothing I can do about it.
But your handler, are you saying that your handler was aware of this and was quite happy with you sharing these documents with Mr. Madlanga?
Let me not incriminate myself.
You see, this is not the only example of bad intelligence practice if your version is to be believed. You say in your statement that your first meeting with Mr. Madlanga was on 7 December 2024. That's at page 9 of your statement. Paragraph 32.
Yeah, Chair.
And you stand by that?
No, I'm not going to incriminate myself.
Well, Mr. Mokgotsi, it's a bit too late for that because you've stated that under oath in paragraph 32 of your paragraph.
It means all the evidence that I've given will stand. I'll not retract or change. From now, let me not incriminate myself.
I see. Well, you then say, and 7 December was the day after the raid on Mr. Madlanga's house. You're aware of that? The raid was on the 6th of December.
Let me not incriminate myself.
Mr. Mokgotsi, you are refusing to answer the question. It's not an incriminating issue. You simply refuse to confirm that the 7th of December was a date after the raid on Mr. Madlanga. And that's it. You're refusing to answer the question.
Commissioner, I'm going to give an answer, Commissioner. You see how I incriminate myself. I met Kate on the 7th of December. I may not remember if it was a day after he was raided.
I don't see anything incriminatory in that answer.
Let's check the next question.
The next question is, you met him on the 7th, and on the same day, we see in paragraph 33 that you activated your handler, who you say is Mabazela, but now you say is Mabuza, to arrange for Madlanga to open a criminal case at SAPS in Soweto. Mabazela, you said, but you now say Mabuza, then spoke to my co-handler, who then facilitated the opening of the docket. Do you stand by that as well?
It's in the statement.
Yes, but I'm asking, do you stand by it?
I stand by it.
You see, your co-handler said that the request came straight from you, not from Mabizela or Mabuza. The request to open a docket for this person.
Yes, I may have called him also, because I talked to them both.
Okay. Your co-handler also said that at that stage he was unaware that you were investigating Mr. Madlanga.
Is it possible? It's possible. If I request...
It's possible.
Yes, any high-ranking officer, you ask him, may you assist someone to open a case? He won't ask you if you're investigating, why are you opening a case? He'll just help the person.
Yes, and he said he didn't even know that it was Mr. Madlanga you were asking to open a case for. It was just some person.
Yeah, it's possible. He didn't know.
Yes. He was very clear that it was not good intelligence practice to put a target in contact with a member of crime intelligence who was playing a supervisory role in relation to the investigation of the target. So he was clear on that. So the tenor of his evidence was that if he knew you were investigating Mr. Madlanga and he knew that you were asking him to open a case for Mr. Madlanga, he would not have put himself in a position where Mr. Madlanga saw him and knew that you were dealing with him. What's your response to that?
See, one of the reasons Mr. Madlanga had to open, he's staying in Pretoria. One of the reasons he had to open a case, I did say that previously, the same to the arrest of General Kuman. The case was opened in Cape Town by a member of parliament. It could not be investigated. The same person came to Soweto in Orlando to open a case because there was this thing of station commissioners communicating or being instructed by their provincial commissioners that this case, this one, don't open. So for me to say, help someone to open a case, it is not about intelligence practice or not. It's to ensure that a person is able to open a case.
Yes, but you can get a case opened without exposing your supervising handler, or co-handler, as you say, to being known by someone who is a target of an investigation that he is supervising.
Chair, the man could not open a case in Brooklyn, even in Location Township in Pretoria. Once you are a target, you cannot open a case.
Why was it so important to get this case open?
He wanted to open a case. If a criminal charge is to be laid, it doesn't come with importance or non-importance.
And so you were prepared to expose your co-handler's identity to this man because you thought it was important for the case to be opened?
No, Chair, you call, please assist this person to open a case. You don't say, my brother, I now expose you, going to open a case. This man is from crime intelligence. Let me show you. No. Even himself, he didn't open a case for him. He spoke to someone, please assist this man, and he left, according to him.
Yes, but according to him, he met Mr. Madlanga outside the police station.
That's correct.
Didn't know it was Mr. Madlanga, he says, but...
Yeah, it means he didn't know him, and
yes.
He didn't know him.
Yes. But he was very clear that it is very poor intelligence practice to put Mr. Madlanga, who was a target, in contact with the supervisor of the investigation into Mr. Madlanga.
Yeah, no, I have no comment. That's what he's clear about.
Yes. And it goes further, because a few weeks later, you not only gave Mr. Madlanga the name of your co-handler, but you also gave him his ID number. Take a look at page 84. Do you remember when you did this? When you wanted Mr. Madlanga to pay for your co-handler's ticket?
Yeah, and I believe it is in the statement where I explained why I needed to go with a co-handler in Cape Town.
Yes, but why was it necessary to give Mr. Madlanga his name and ID number?
You see, when you purchase a plane ticket, there's nothing else you can use except an identity document. And Mr. Madlanga could not prophesy that this man is who and who. He didn't know him. He could never know. It happens every time, even here, when an operation is done. You don't tell people this is this man.
Mr. Mokgotsi, your co-handler's name is all over the press as a senior crime intelligence official. Anyone who showed any interest in these people would have been able to identify the fact that one of the people who you had asked Mr. Madlanga to buy tickets for was a crime intelligence official.
I know how that leaked.
Long before this commission got set up,
yes.
Do a Google search. You'll find lots and lots of references to your handler and his role in crime intelligence.
Okay. That is true.
You see, what I want to put to you is that none of these dealings, in terms of which you exposed your co-handler to Mr. Madlanga, make any sense if Mr. Madlanga was an actual target of your investigation. And what I want to put to you is he wasn't a target of your investigation at all. In fact, he was someone who you hoped to work with against the real target, who was General Khumalo. What's your response to that?
No comment. I'm not going to implicate myself.
You're not going to incriminate yourself.
Yes. That's correct.
Let's look at your interest in General Khumalo. Let's start with your approach out of the blue to General Mkhwanazi. Remember in September, out of nowhere, you send him WhatsApps. Can you go to page 290 of the exhibits file? 290. Do you have it?
That's good.
Now, these are the WhatsApps that you describe as having been sent to General Mkhwanazi in your statement as a way of making contact with him. And your opening gambit on the 30th of September, you say, "My General, Brown Mkhotsi from the Northwest, an internal attempt to discredit you through a defeating the ends case." That's the 30th of September. General responds to you the next day and says, "Morning, sir, what you talking about? What defeating case are you referring to, and who's behind it?" And just remember, he's asking who's behind it. You immediately forward him the Mpangeni occurrence book. And then if we go down all the way to page 292, you answer his question, who's behind it? When at 9:19, you say, General Khumalo, DivCom, just check your standing with him. Yesterday, he pushed a negative narrative about you on the CITs in KZN. The same complainant spoke with him. And that's a reference to the complainant in the Mpangeni case, who you've referred to at 7:51 when you say, "I'm meeting with the complainant, will revert." You with me so far?
That's correct.
Go over the page, 293. That text we've just seen is at the start, and in fact it comes above a crime intelligence presentation. So when you say General Khumalo DivCom is behind this attempt to discredit General Khumalo, yesterday he pushed a negative narrative about you on CITs in KZN, you actually attach
To discredit General Mkhwanazi.
General Mkhwanazi, you attach a screenshot which shows a crime intelligence presentation. And then General Mkhwanazi responds to your Mpangeni materials. He says, "I know that matter very well. An illegal operation was conducted at the premise of a high-ranking DCS official." We go down through 294. He gives his whole version on the illegal search at the prison officers. But he responds to your suggestion that General Khumalo is behind this attempt to frame him with a defeating the ends case, which we see at the top of page 295. He said, "What did he say about me?" Responds to your General Khumalo DivCom, just check your standing with him. And, yeah, it was your message. He says, "What did he say about me?" You respond at 9:37. And you say, in response to what General Khumalo allegedly said about General Mkhwanazi, you say that he said you, in other words, General Mkhwanazi, are having your interest and that maybe you're having your own cartel. You don't listen to crime intelligence. So you are telling General Mkhwanazi that General Khumalo at a crime intelligence briefing said maybe General Mkhwanazi has his own cartel.
Is it not preceded by keep it a secret, as in Jen, this must be in your chest? Then that chat that you just mentioned.
Yeah, indeed, Commissioner. So if we go a step back, you respond to General Mkhwanazi when he says, what did he say about me? Jen, this must be in your chest. He responds, trust me on this one, and then you give the answer. You're having your interest in that maybe you're having your own cartel. You don't listen to crime intelligence. Then Masemola intercepted him. Also spoke about your provincial crime intelligence. Remember, he's retiring next month. And General Mkhwanazi is clearly concerned. He says, please get me that presentation if there is one to confirm, or otherwise if there's any recordings. And you respond to that, nothing. In other words, there are no recordings. General Khan will brief you next week. So that's what the exchange was. And what I want to put to you is that the overall picture is that you are making very serious allegations against General Khumalo to General Mkhwanazi. You're suggesting that General Khumalo is trying to frame General Mkhwanazi, is trying to link him to cartels, and that General Khan will be able to tell General Mkhwanazi more about the treachery of General Khumalo. What's your response to that?
Thank you, Chair. You know, this I'm going to respond because it's in my statement. Like I say, what I said in my statement still stands. Logically, anyone here, if you can pick up a phone and send a message to General Mkhwanazi or any general in the province, he won't respond. The time I told you about the legend building, that is the legend building at its best. A man who doesn't know you get to talk to you. When I brought the application here for your recusal, I led you, or I didn't lead you. It's because you called me. You were talking, but I heard that you wanted to do something. That's what an agent does. Immediately when there's an opportunity of information, you utilize it. Like the word Khan, General Khan, is known in the crime intelligence. It's not my friend. In my previous statement, I said I met him once, greeted him from the car, but I knew when I used this name. Look how General Mkhwanazi responded. In full, he explained to me what happened. He will not, Lieutenant General will not respond to those things if you don't tell him what he wants to hear.
You see, why General Mkhwanazi would be interested in responding to you, I want to suggest, is not because of any dramatic legend building that you did in this exchange, but because you clearly had access to a crime intelligence briefing, and you gave him a screenshot. Where did you get that screenshot?
Let me not incriminate myself.
Are we no longer answering questions now?
No, obviously I'm going to say a source. You ask me what is the source.
No. Saying a source is not necessarily incriminating yourself unless your conduct in relation to that source was illegal.
I'll say it's a source.
Well, I want to know the name of the source and how I can contact that source. And are you saying that, that if you were to give that information away, you would disclose that you have committed an offense by getting this crime intelligence briefing cover page? Is that what you're saying?
I don't understand the question, Chair.
Answering that question cannot incriminate yourself.
Okay, but I don't want to incriminate myself.
I know you don't want to incriminate yourself, but I am asking you, if you were to give me, with the mere fact of the name of the person who, name and details of the person who gave you that cover page, expose you to criminal prosecution? Because if not, you're obliged to furnish it.
If I don't give the name?
No. If by giving the name you have exposed yourself, you have disclosed that you have committed an offense, then you don't have to. If by giving the name you are not disclosing that you have committed an offense, then you're obliged to.
Yeah, but then I don't want to incriminate myself.
So you're saying that if you were to give me that name, it would be evidence that you have committed an offense?
Answering these questions leads me to incriminate myself.
No. Answer the specific question that I just asked you. If you were to give me the name of the person who gave you that Division Crime Intelligence slide, would that disclose that you have committed an offense? The identity of that person would be sufficient to show that you have committed an offense.
I don't. But it's if I say it's a source, means a source is a source.
No, I'm not interested in sources. I want people I can speak to.
No, Chair. There's no way you can get a source name. A source? Never.
Chair, I must ask you to instruct the witness to answer this question. It seems that he wants to protect his source, which is different from asserting a privilege against self-incrimination. He can disclose the matter, doesn't need to give the name publicly. He can write it on a piece of paper like he did last time, and we will keep it confidential.
A chain of information of this nature, it will come from this person, goes to my handler, comes to me, maybe I give it to somebody. And if my handler is the one who got it, may his soul rest in peace.
Well,
Mr. Mokgotsi, this is not about self-incrimination.
Yes.
It is simply not. So it's just a question of either giving the information or plainly refusing to give it. It has nothing to do with the self-incrimination.
So, Chair, is a witness compelled to give a name of a source in the commission?
The witness is compelled to give evidence, and this relates to exactly that. This is about evidence. And if the issue is not divulging it openly, you can give us the name. You can write it down and give it to us. It has nothing to do with self-incrimination.
All right. I will write it down. I'll talk to my lawyer to give it to you.
You are on the witness box now. You have to answer. The question is asked now. You have to answer it now. And you've been given the option to write it on a piece of paper and give it to us.
Yes.
Your legal representatives are not testifying, Mr. Mokgotsi.
No, I can write it down.
Yes. Give him a piece of paper.
They are borrowing me now.
I could have predicted it would be a dead person.
But Chair, you heard that's the person I was working with is the only one who had access to that. Now, how
Sorry?
You even told me that my co-handler did tell you who I was working with, who had direct communication with the crime intelligence, is the only one who could give me that. Now, if questions are posed when there are predictions, Chair, please protect me.
Yes, Mr. Joseph.
Sir, the source was not in fact a source at all, was he?
Chair?
The source was not a source at all. The person who gave that cover page to you, you said it came from a source, you didn't want to disclose a source. That was false, was it not?
It's not false. You see, there is life and there are families who are still alive. In this environment, giving out people's names, whether alive or not, you really put their families in danger.
But the fact remains, you didn't get that information from a source at all. You didn't receive it from a source.
No, he was my source.
The Commission and I know who he was, and I put it to you that he was not a source at all.
And Chair, isn't it worrying that the person you are referring to 2 days before he had to come here, something horrible happened to him and he passed on? When the family went to collect his body, the same police officer was shot at, same number of bullets like me. None of the bullets touched him. At least they never said he shot his own car and he shot himself. He was almost killed. That captain who went to fetch the body of the same person.
Are you saying that had anything to do with him giving you this screenshot?
No.
What you're describing?
No, I'm saying there is a lot that is happening, Commissioner.
Okay. No,
Yes.
I just wanted to be clear that are you connecting it to this screenshot?
You see, Mr. Mokgotsi, there is another way of looking at all of this. The person who passed away 3 days before your alleged co-handler was going to meet us was someone whose existence we knew nothing about. Warrant Officer Mabuza was someone whose existence we knew nothing about. We learn about these people. For the first time they get mentioned a long time after they have passed away, when of course they're no longer around to be able to contradict the things that are said about them. And it is very disconcerting to me that you are able to mention Warrant Officer Mabizela, who was arrested several years ago and never played any role at all in your handling, in your witness statement. You don't mention Warrant Officer Mabuza. You mention your co-handler and you give us your name, his name. We go to speak to your co-handler, he says nothing about Brigadier Duma. And then after Brigadier Duma dies, he suddenly becomes the key to this entire operation. It does seem to me that you are pinning on a dead man responsibility for what looks very much like a renegade crime intelligence operation. And it's very convenient to have a dead man to pin it onto. What's your response to that?
No comment, Chair.
Do you have any evidence of having met Brigadier Duma at any time? Any extrinsic evidence that will satisfy us that you met Brigadier Duma before he passed away?
I don't know what kind of evidence you want.
Sorry, I could not hear you.
I don't understand the kind of evidence he refers to. For example, you just spoke about Lieutenant General Sibiya. I cannot give you any evidence that I met him. If people met, and this thing operates differently. We don't take pictures. You can't say, hey, I was with this man, then we take pictures.
If we look at your cell phones, will we find the geolocation showing that you were ever in the same place together?
Yeah, that if it's utilized, yes, definitely, more than once. More than once.
And maybe you could give us some dates to look at.
No, I can't remember the date.
Not even, I mean, Brigadier Duma passed away 3 months ago.
But it cannot be dates. If you do your section 205, I can tell you locate me with the same person.
You give us some approximate times when you say you met with Brigadier Duma and where, and we will do that exercise.
Yeah, I'll try and check when was that. The last time. Oh, you want them now here?
Yeah, no, I would like to have them here.
Even this year, was it no, December.
And where would you meet Brigadier Duma?
Even at the office, at his office.
At his office?
Yeah.
Now, his office is in the same building as your co-handler.
No, yes, you also have an office.
Yes, it is.
You also have
So
an office there.
it's not going to help us to look for meetings at his office, because if you go to meet your co-handler who admits to meeting you, you will be seen in the same position.
No.
I want a location outside the office.
No, that's the only help. That's the only place we'll meet.
You only ever met Brigadier Duma at his office?
I met him at his office.
Yes. How many times did you meet at his office? If we go and look at access records at that office building, will we find you coming in and out to see Brigadier Duma?
Yeah, but we can go and check. We'll never find, even when I went to see my client, I don't sign. You'll never find my signatures or name there. And you'll see most of the time where people meet, when you get there, there is a way of meeting.